ಎಸ್ ಸರ್ ನಾಯಕ್ರೆ. KPSC ಅಲ್ಲಿ KT ಮುಂದೆ ಮೇವ ಆರ್ಡರ್ ಇದು ಇದ್ರ ಅಲ್ಲಿಲ್ಲ ಮತ್ತೆ ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ ನಾವು ತೊಳಿ ತರಿಸಿ ಅಂತ KT ಮುಂದೆ ಇರೋದು ಎಲ್ಲರನ್ನೂ ತರ್ಸ್ಕೊಂಬಿಡಿ ಹಿಂಗೆ ಅಂತ ತರಿಸಿ ಅವ್ರದ್ದು ತೊಳಿ ನೋಡೋಣ ಎಂತದ್ರ ಒಂದು ಆಟ KT ಕೊಡಿ 5ನೇ ತಾರೀಕು ತಾನೇ ಅದು. ಎಸ್ ಅವೆಲ್ಲ ತರಿಸಿ ಆಸ್ ಈಸ್ ವೇರೀಸ್ ಹೆಂಗಿದೆ ಆ ಸ್ಥಿತಿಯಲ್ಲಿ ತರಿಸಿ. 5ನೇ ತಾರೀಕಿದೆ ಎಕ್ಸಾಮ್. 3ನೇ ತಾರೀಕೆ ಇದೆ ಆಯ್ತಾ ತರಿಸಿ ತರಿಸಿ. ಈಗ 2:30 ಅನ್ಬಿಡಿ, ಈಗ ಬಂದ್ಬಿಡ್ಲಿ ಅದೆಲ್ಲ ತರಿಸ್ಬಿಡಿ ಜೊತೆಗೆ ಬಂದ ತಕ್ಷಣ ಕರೆದ್ಬಿಡ್ರಿ. Arrest warrant has been issued. ತರಿಸಿ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರ್ ತರಿಸ್ಲಿಕ್ಕೆ CJ ಇದು ಬೇಕು ಆರ್ಡರ್. ಇದ್ರ ದಿವಸ ಹಾಕೊಳ್ಳಿಕ್ಕೂ ಬರಲ್ಲ. 2ನೇ ತಾರೀಕು ಹಾಕೊಳ್ಳಿ, 2nd ಹಾಕೊಳ್ಳಿ. ಬೇರೆ ಬೆಂಚ್ ಮುಂದೆ ಬರುತ್ತೆ. ಎನಿವೆ ಬರ್ಲಿ. ಒಂದು ಸಬ್ಮಿಷನ್ ಮೊದಲಿಗೆ ಮೆಮೊ ಅದು ಮೈಕ್ ಹಾಕೋಬೇಕು. ಏನ್ ಅದು ತಿಳಿಯಲ್ಲ ಅವ್ರಿಗೆ.
This case of demotion
ಯಾವಾಗ ಆಗಿದೆ ಅದು?
About 6 months back.
6 months back.
Subsistence allowance that's kindly out on the second one because no subsistence allowance is also not paid.
Suspension allowance ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಡ್ತಾ ಇಲ್ಲ ಅದನ್ನ. Kindly out on second man.
Move in the vacation ಕೊಡಿ, ಬರ್ಕೊಳ್ಳಿ ಅದ್ರ ಮೇಲೆ. Permitted to move in the vacation.
That's the kindly out on second man.
Yes.
Kindly Friday my lord on matter. TV ರುದ್ರಪ್ಪ ಕವರ್ಡ್ ಆಗಿದೆ
ಆಫ್ಟರ್ ವೆಕೇಶನ್
ಈ ವಾರ ಅಂತ ಹೇಳಿದ್ರಿ ತಾವು.
ಹೆಂಗೆ ಹೌ ಇಟ್ ಈಸ್ ಇಂಪಾಸಿಬಲ್. ನೀವೇ ನೋಡಿರಿ KPSC ಮಕ್ಕಳೆಲ್ಲ ಬರ್ತಾ ಇದ್ದಾರೆ ಪಾಪ, ಎಕ್ಸಾಮ್ ನಡೆದಿದೆ ಅವ್ರಿಗೆ.
ಶಾರ್ಟ್ ಇಶ್ಯೂ ನೋಡ್ ಮೇಲೆ
ಕರೆಕ್ಟ್ ಎಲ್ಲವೂ ಶಾರ್ಟ್ ಇರ್ತಾವೆ. ಯಾವುದು ಕೇಶವಾನಂದ ಭಾರತಿ ಮತ್ ಬರಲ್ಲ ಕೋರ್ಟ್ ಮುಂದೆ.
Writ filed by the state, my lord, because of pending contempt proceedings, my lord. It's coming up on contempt matter is coming up on 9th and the personal presence of the principal secretary. 9th of May, my lord. May. Next month, man. 9th May.
ಮೇದಲ್ಲಿ ಹೆಂಗ್ ಬರ್ತದೆ?
Date ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಡೇಟ್ ಕೊಟ್ಟಾರ?
Date ಕೊಟ್ಟಿದ್ದಾರೆ.
Second ತರಿಸಿ.
My lord, this matter which came up for hearing on the 2 days ago, my lord, matter relating to PDOs, the challenge to the amendment making the district level cadre as a state level cadre, my lord. It was your lordship passed an interim order not to take any precipitative action pursuant to the amendment.
Correct.
My lord, application for vacating has been filed because of the new developments which have taken place, my lord, regarding
ಏನಾಗಿದೆ ಆಫ್ಟರ್ ವೆಕೇಶನ್
ಅದು
permitted to move vacation.
permit, please.
Permitted.
Grateful.
Vacation. Welcome.
Consumer Forum case. Warrant has been issued.
Warrant
issued. I am ready to deposit your worship.
ಎಲ್ಲ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀರಾ?
50% deposit.
ತರಿಸಿ 2ನೇ ತಾರೀಕು ಬರಲಿ.
Yes.
50 ಅಲ್ಲ 100% ಡೆಪಾಸಿಟ್ ಮಾಡ್ಬೇಕು.
Yes, this is regarding the KPSC matters, the anomaly in the question paper from Kannada to English.
ಇದೆಯಲ್ಲ ಇದು ನೋಡಿ.
May I request not 2:30 minutes.
ಏನ್ ಅರ್ಜೆನ್ಸಿ?
Petitioner is not of the forest guard. Is posted to not of the protection duty, not of the Chengiri. 4 months back, not. Now, not of the government issued a notification showing not his place as vacant, not is somebody trying to fill up that thing.
ವೆಕೇಶನ್ ಮೂವ್ ಮಾಡಿ.
May I request may I request at least day after tomorrow. Second ಗೆ ಮಾಡಿ. ಅಲ್ಲ ಸೆಕೆಂಡ್ 4 ತಿಂಗಳಾಯ್ತು.
ಇರ್ಲಿ ನೋಡೋಣ. ನೆಕ್ಸ್ಟ್
second may I request?
Very good. Yes.
My lord, serial number 27, my lord.
27. ಅಲ್ಲಿ ಮೈಕ್ ಉಪಯೋಗಿಸಬೇಕು.
Filing memo for withdrawal, my lord.
Withdrawal. Very urgent. ಕೊಡಿ ತೊಳಿ. Very urgent matter. ನೋಡಮ್ಮ ಬರ್ದು ಹಾಕಿ. Memo reads as under ಅಲ್ಲಿ ಗವರ್ಮೆಂಟ್ ನೋಟಿಸ್ ಆಗಿದೆನಾ? ನೋಟಿಸ್
ಆಗಿದೆ.
ಮಾಡ್ಕೊಂಡು ಓಕೆ, ನೋಡ್ಕೊಳ್ಳಿ ಯಾರು ತೋರಿಸ್ತೀವಿ.
Serial number 43, my lord. Serial number 43, my lord.
43
Yes, my lord.
ವಿಡ್ರಾವಲ್ಲ?
Withdrawal, my lord.
ಅದು ಅರ್ಜೆಂಟ್, ಅದು ಕೊಡಿ. ವಿಡ್ರಾವಲ್ ಇದ್ದಂತ ಕೊಟ್ಬಿಡಿ, ಅವು ನಮ್ಗೆ ಬಹಳ ಅರ್ಜೆಂಟ್ ಇರ್ತದೆ. Yes. ವಿಡ್ರಾ ಮಾಡಿದ್ದು ಬಿಕಾಸ್ ಯು ಆರ್ ನಾಟ್ ಹ್ಯಾಪಿ ವಿತ್ ದ ಕೋರ್ಟ್ ಆರ್ ವಾಟ್ ರೀಸನ್?
No, my lord. We want to pursue the
Your remedy
remedies
elsewhere.
with the state itself, my lord.
Okay.
Please.
In terms of memo ಅಂತ ಹಾಕ್ಬೇಕಾ?
Serial number 43.
Yes.
Petition. There are three small office objections, my lord. I'll comply today itself, my lord, except translated copies. That may be kindly dispensed.
The urgency in the matter because, my lords, the petition, the respondent number 3 is getting retired in June. My lords, the allegation is of 2006. My lords, the impugned order is at page number 16. My lords, there is no
My lord, one
specific
submission.
allegation against him. My lords, my only submission is, out of 3 persons where the allegation is done. My lords, the
One
one
submission.
person,
In
my lord,
Immediately after vacation.
Please, in respect of other DGO, my lord, Honorable KAT, by relying upon that order, my lord, this appeal has been allowed. My lord, that writ petition is pending before the Honorable Court.
that's my
Call
contention.
It may
along
be
with,
call along with, I'll furnish a number to the court.
sorry, call along with,
My
in
only
the first week of June.
My lords,
Please.
only one submission, my lords.
ಅಲ್ಲ, ಅದರ್ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಪೆಂಡಿಂಗ್ ಇದೆ.
My lords, other than that one, my lords, what happened? Totally 3 persons were there. My lords, one person, they said on delay in
ಫಸ್ಟ್ ವೀಕ್ ತಗೊಂಬೋಣ.
First is first week.
ಓಕೆ. ನೆಕ್ಸ್ಟ್
Translated copies may kindly be dispensed.
ಡಿಸ್ಪೆನ್ಸ್ಡ್ ಇಸ್.
Please.
ನೆಕ್ಸ್ಟ್.
Oblige.
For the,
ಹಾ.
for the petitioner, my lords. So for his production of, lords, the translated copy, my lords, we filed an application seeking dispensation.
ಫಿಫ್ತ್ ಟೈಮ್ ಅದೊಂದೇನಾ? ಅದೊಂದು ಡಿಸ್ಪೆನ್ಸ್ಡ್ ಇಸ್.
Lords, this, so far as the impugned order is concerned, it's a remand order which is in challenge.
ಹಾ.
At, lords, pursuant to the order passed by the KAT.
ರಿಮೈಂಡ್ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು, arising out of the same charge memo, my lords, the proceedings have been quashed by the KAT in the pursuant orders.
ಯಾವ್ದು?
I've even marked it as an annexure. Annexure E, my lords,
Sorry.
page number 194.
Emergent notice. Learned DG is requested to accept notice for all respondents. Okay.
So sought for interim order.
ಈಗ ಒಂದು ವರ್ಷಕ್ಕಿಂತ ಜಾಸ್ತಿ 2024 ಮ್ಯಾಟರ್ ಏನಾಗಿದೆ ಈಗ?
ಅಲ್ಲ, ಇವಾಗ because 2 increments have been withheld. and
ಅಲ್ಲಿ
it's going to
ಎಂಟ್ರಿ
retire
ಮಾಡರ್ ಇರಲಿಲ್ಲ.
ಅಲ್ಲಿ
KT ಯಲ್ಲಿ.
ಅದು ನಂಗೆ ಮಾಹಿತಿ ಇಲ್ಲ.
KT ಇತ್ತ ಎಂಟ್ರಿ ಮಾಡರ್ ಏನಾರ ಇತ್ತ? ಮಾಹಿತಿ ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ರಿ ನೀವು.
ಎಲ್ಲ ನೋಡ್ಕೊಂಡ್ ಬರ್ಬೇಕು ಸರ್.
ಎಷ್ಟು ವರ್ಷ ಇದೆ ಸರ್ವಿಸ್?
Lords, he has 1 more year, 1.5 years service.
ಮತ್ತೆ ಅದನ್ನ ಸ್ಟೇ ಮಾಡಿದ್ರೆ ಮುಂದೆ ಇನ್ಫೆಕ್ಷಸ್ ಆಗಿಬಿಡ್ತದೆ ನಿಮ್ ಪರವಾಗಿ. ಹಂಗ್ ಮಾಡಕ್ ಬರಲ್ಲ. ಸ್ವಲ್ಪ ಲಾಂಗ್ ಸರ್ವಿಸ್ ಇದ್ರೆ ಸ್ಟೇ ಕೊಡ್ತಿದ್ವಿ. ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್. Vachan.
This matter, the sub-registrar's matter. Notes, this is that sub-registrar's matter where, my lords, Supreme Court had directed, my lords, requested this honorable court, my lords, to take up the matter for final hearing. And I had made a submission, my lords, that the state's SLP was coming up.
Yes.
Before the Supreme Court, my lords, I deferred. Nenne ittu Swami, one Friday, judge, the sitting was cancelled. Yesterday, my lords, this honorable court's order has been stayed by the Supreme Court.
Stayed by the Supreme Court. Then very
So
good.
after vacation.
So call after vacation. It has been stayed by the court.
Please, my lords, interim order.
Correct. Once interim order is stayed, can we grant interim order again for one more? AAG, Mr. Jacob submits that the interim order granted by this court in the writ petition number
Notes, in all the writ petitions, 18/2/2025.
2025 has been stayed by the apex court in SLP number
10482 to 10490 of 25.
on,
Yesterday.
no, no. Signed, so first, in view of that,
My lord's order is not stayed. Only last order.
that's all right. Other order of stay ಆದ್ರೂ ನಮಗ್ ಸ್ಟೇ ಇದ್ದಂಗೆ ಅದು.
ಇಲ್ಲ,
ಹ.
ತಮ್ಮ ಆರ್ಡರ್ ಸ್ಟೇ ಆಗಿದೆ. ಅಲ್ಲಿ ಏನಾಗಿತ್ತು, ತಾವು ಇಂಪ್ಯೂನ್ ಆರ್ಡರ್ ಸ್ಟೇ ಮಾಡಿಲ್ಲ. ತಾವೇನ್ ಹೇಳಿದ್ರಿ, 3 conditions are passed while granting interim order. That is not stayed.
It is not stayed.
Only 10/12/21.
18, Lords, our grievance was this.
18 to 25 order is stayed.
Lords, 10/12/2024, my lords, we have notified the transfer counseling, transfer notification. 16/12, my lords, before my lords, the matter had come. My lords had passed an interim order, my lords, with regard to 3 subparagraphs, categories of employees who can go and take charge, who cannot take charge. That we have implemented, my lords. On 31/12, it had come before the vacation bench headed by my lords. My lords had given them the login credentials. We have complied with that orders, filed compliance affidavits. Thereafter, my lords, they had filed one more application. They sought stay of the 10/12 notification itself. My lords had passed an interlocutory order in after we had complied with the 10/12. Now 10/12 was subsequently stayed by this honorable court in the month of February. Thereby, my lords, putting the clock back insofar as we had already implemented the interim orders. So that order has been stayed by the Supreme Court. So therefore, the only request was in the previous cases where the other persons had gone was to take it up for final disposal.
We cannot grant interim order.
Therefore, my lords,
All
after
these-
vacation.
But submitted, full stop. In view of that at this stage, interim order cannot be granted. Okay.
Grateful, lords.
Interim order is ಎಲ್ಲಾದ್ರು
ಇದೆ exist.
ಅದು ಅಷ್ಟೇ ಆಗಿ ಹೋಗಿದೆಯಲ್ಲ.
ಅಲ್ಲ 2 interim orders were there. One interim, later interim order stayed.
Anyway, sorry, call after vacation.
Please.
In view of this, all these matters.
16/12/24 order may be extended, nothing else.
ನೋಡ
ಅಲ್ಲ ಯಾಕಂದ್ರೆ otherwise ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ
ಏನೂ ಆಗಲ್ಲ.
government has clarified it.
ಅದರ್ವೈಸ್ ಇನ್ನೊಂದ್ ಕಡೆ ಕೆಲಸ ಮಾಡ್ತಾರೆ. ನೆಕ್ಸ್ಟ್ ಏನ್ ನಾಗರಾಜ್?
Production of English version may have filed application for dispensation. The interim, the impugned order is concerned, my lord, the Honorable Administrative Tribunal remitted back to the matter to Lokayukta.
For reconsideration.
No, reconsideration from the stage of processing complaint, my lord. Here I am with 2 grounds, my lord. One is, my lord, he retired in the year July 2020. Incident took place in the year 2019, my lord. Law doesn't provide to initiate departmental inquiry so far as.
No, initiate andre already initiated, but set aside, remanded adag initiate agalla.
No, my lord, here from the stage of processing complaint, my lord. It is not from the stage of furnishing articles of charge. That is one aspect. Secondly, my lord, there is clear acquittal order, my lord, in the criminal proceedings. Lordship, page volume number 2, my lord.
PV Rudrappa bartada.
Yes, my lord. PV Rudrappa is the acquittal order is
acquittal
honorable acquittal in nature, my lord. Page number 317, my lord, volume number 2.
317.
Yes, my lord. Shadow witness was not examined, my lord, and also enmity between the complainant and delinquent employees also found proved, my lord.
Finding ತೋರಿಸಿ.
Yes.
ಅವು ಐದು ಪಾಸ್ಟುಲೇಟ್ಸ್ ನೇ ಬರಬೇಕು ಯಾವ್ದಾರ ಒಂದರಲ್ಲಿ, ಅವಾಗಷ್ಟೇ PV ರುದ್ರಪ್ಪ.
Page number 140, sorry, page number 406, my lord, paragraph 148.
406.
Yes. May I read, ma'am?
Come to 407, brother, government.
Please.
Item 3. ಅಲ್ಲಿ ವಿಂಡೋದಲ್ಲಿ ಇಟ್ಟು ಹೋದ್ರೆ ದುಡ್ಡು ಅವನೇನ್ ಮಾಡ್ಬೇಕು? ಅಲ್ಲೆಲ್ಲರ ಪೋಸ್ಟ್ ಬಾಕ್ಸ್ ನಾಗ ಹಾಕ್ಲಿಕ್ಕೆ ಹೇಳಿಕಾಗಿತ್ತು ಅವನಿಗೆ. ಇಶ್ಯೂ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್, interim order as prayed for, learned AG is requested to accept notice for so and so, learned panel counsel for so and so. Barkade. This interim protection is granted in the light of certain observations made by the learned first additional session judge at Shivamogga in special C PC bracket complete number 8 of 2016, disposed of on 30/9/2024, whereby acquittal has been recorded. Arguably, the same being honorable acquittal in the light of PV Rudrappa.
Much.
Interim order till next date of hearing.
Office objections. One is, my lord, what happened is these appeals were filed on January 6th. We didn't know that January 4th was a working day. So 2 days delay is there. We have filed applications for continuation of 2 days delay.
Delay may be condoned, my lord. I have no, matter may be after vacation.
The thing is, we need some protection until
My lord,
then.
the order is dated 11/24. There's no question of protection. It's contrary to the
Have you
statute.
implemented it?
The demand notice is issued
It
now.
may be of 2024. Have you implemented?
Demand notice is issued just a few days
My
back.
lords, demand notices issued. Kindly see, my lords, let him show where the subcontractor reflects these amounts in his returns in compliance with the statute. There cannot simply be a production.
Aditya, that is on merits.
On merits, my lords.
On merits.
He has to show his case.
First appellate authority has granted me relief.
Application supported by an affidavit seeking condonation of delay is favored. Plausible cause being shown and delay being too short to be lethal. First stop. Precipitatory action to bid. The respondents are restrained from taking up any precipitatory action pursuant to impugned order till next date of hearing. First stop. Call this matter in the first week of June 2020.
Right. 6 and 7 are same.
Same. 5, 6, 7. Along with each other?
Yes, all.
Call along with each other.
Great.
Office objection ಏನದು? Surya.
One 2 days delay,
Okay.
for which we have filed application. Other is they wanted a lengthy affidavit. We have made the application lengthy and affidavit is short.
Office objections not being much significant overruled.
Great.
Yes. Basuraja. Times ಏನದು? And it's a A1.
My lordship, we have filed it in KSAT.
You have filed it in CH-8.
KSAT.
ಏನಿದು ಮ್ಯಾಟರ್?
About the compassionate apartment of the daughter.
Take emergent notice.
Yes, my lordship.
Lord, on
Short
the last
point-
occasion,
short
this
point-
matter was listed for today because there is a short question involved, my lord. She was age barred as on the date of the death of the.
ಎಷ್ಟು ದಿವಸ ಆದ್ಮೇಲೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಯಾರ?
ಒಂದ್ ವರ್ಷ ಆದ್ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ, ಬಟ್
My
ಡೆತ್
lordship-
ಆದಾಗೇನೆ ಏಜ್ ಬಾರ್ ಆಗಿದ್ರು.
No,
ಅಗ್ಬಗೆ ಆಗಿತ್ತಾ?
41 years.
No, my
She is
lordship.
a ST
No, my
candidate,
lordship.
ST candidate.
For
She
the
was-
for the group D post, 5 years relaxation is there.
ತೋರಿಸಿ.
Kindly see page number one.
After vacation.
Kindly see page number 126, my lordship.
Kindly have it after vacation.
My lordship, it is short.
ನೋಡೋಣ. ಏನೋ ಅರ್ಜೆನ್ಸಿ ಇದ್ದಾರೆ, ಅನೇಕ ಜನ ಎಕ್ಸಾಮ್ಸ್ ಇದಾವೆ ಓದಕ್ಕೆ, ಹಂಗಾಗಿ ಅಭ್ಯಾಸ.
Serial number. My name may be deleted from the cause list because I have tendered NOC. And
Jay,
He has issued NOC. I have filed
Yes.
NOC.
why you are not happy with the court?
my lords, it's not about the court, my lords. In the last occasion, my lordship had observed few things, so.
Third. Chiranjeevi, Mr. Chiranjeevi KR, learned counsel is permitted to retire from the case, and in his stead, Shri Prithvish appears. Okay.
Great. Lord, serial number 9 is a matter, my lords, where my lords had already granted the interim order. There were parties. I don't know, for some reason, totally 5 cases, my lords had granted interim orders. 3 matters, all the matters were connected, but only 3 matters, my lords, they have moved it again. I don't know why it was moved.
I have moved the matters because the other remaining fresh matters are also listed before your lordships. Your lordships might take a holistic look. That's why I'm not. Serial number 9, serial number 11, 12, 13, 17, 26, 33.
Same matters, sir.
All are same matters. Common order of the
9 was a matter where my lords, this was 9 matter had come up, my lords, where my lords have already granted interim orders. So anyway, for some reason, they have moved it and got it listed so that it could be.
ಅಲ್ಲ, ಎಲ್ಲರ ಜೊತೆ ಬರ್ಲಿ ಅನ್ನೋ ಕಾರಣ. Chiranjeevi said, let all matters come together so that one for all something can be done. ಯಾವ್ದಾದ್ರಲ್ಲಿ ಇಂಟ್ರಿ ಮಾಡ್ರೆ ಯಾವ್ದಾದ್ರಲ್ಲಿ ಕೊಡ್ಬೇಕಾಗುತ್ತೆ.
Lords, 9 ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವಾಗ.
ಕೊಟ್ಟಾಗಿದೆ.
9, 9.1, 9.2 and 2 other matters, my lords had granted which are not listed. In fact, there was a direction to list along with 9.
ಇದ್ರ ಜೊತೆ ಈಗ ಇದರಲ್ಲೆಲ್ಲ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆ ಈಗ.
ಇದೆ. So they just moved it.
Mr. Naganan.
Our problem, yes, there are.
Harnalli and Naganan, Mr. Harnalli and
Orders, my lord, but we are, my lord, persons who are not before the KAT, and we have a fresh writ petition filed, my lord, that we would like to address your lordships as to how to work out this order, my lord. Because when they went to the KAT, my lord, some of the applicants, their contention was that this question paper was a complete mess.
Now, how can directly you can come, or ordinarily, the apex court said, after L. Chandra Kumar, suppose we have dismissed, we dismissed the SLPs on the ground that you come here because the labor court has already taken a view in a particular matter against you. And directly you come here and we dismiss the WP. Can you go to the apex court on the ground that no, both High Court and Labor Court have already held against us on law. Therefore, you take up the matter directly in the Vartada.
In some cases, my lord, their lordships have entertained such petitions, my lord.
Give me. Kodi.
I'm only mentioning one slightly different facet of the case, my lord. The submission I'm making, my lord. The submission, my lord, that I'm making is that the KAT, my lord, took the view that the procedure followed is wrong. I'm happy with that order, my lord, if that order is given effect to. But they don't give effect to it. There was a committee to be formed. They had to re-examine it and then take a decision. That decision was not taken. And the preliminary exam results, my lord, stood as it is. And thereafter, the final exam is now notified. Now, my lord, if that is to be given effect to, otherwise, my lord, what will happen is people who have not actually successfully participated will be able to come and participate now, my lord. There are 3 or 4 major flaws in it. Supreme Court has said, my lord, the questions are wrong. You must delete the question and give the marks excluding those. Here, what they've done is they've given grace marks. All this the KAT finds is wrong. But instead of asking them to redo everything, they have now, my lord, said, let the committee re-examine it and a decision may be taken. Now, my lord, my predicament is this, my lord. I agree, my lord, I did not go before that the KAT. Now, my lord, there is a series of interim orders granted by your lordships, my lord.
In cases wherever they were before the KAT.
Wherever they were before the KAT, my lord, they came before your lordships, and your lordships have been pleased to grant an interim order to say that they can participate, they can take the examination. Now, my lord, my predicament is that I did not go there, and this final order, the interim order that has been granted, enables some of them to appear. I would also like to have that same benefit, my lord, but my difficulty is, my lord, the examination is 3 days to go.
Correct.
And I did not get any order till then.
No, because you were never before the KAT. You were happy with what they have done.
The
No.
applications filed, my lords, he is posted to today.
KAT nalli
Yesterday, my lords, there were many applications.
Many.
Lords, those applications are posted to today, my lords, for stating that the petition is pending before the High Court, and we are.
In the 2:30 ಇಟ್ಕೋತೀವಿ ಅಲ್ಲಿ ಆದ್ಮೇಲೆ ಬನ್ನಿ.
Ali, they are awaiting your lordship's order.
Unless your lordship clears, my lord, because
We are told that petitioners in WP numbers so and so or before the KAT.
No, they have not.
Not petitioners.
Directly, they have come to the court.
No, they having filed.
ಇಲ್ಲ.
No, our question is how we can give one single precedent. One single precedent. Where directly this court, except in case where about more than 1 lakh employees were dismissed, apex court said, yes, it's a very special case, Tamil Nadu case, Jayalalitha's case.
Rangarajan case.
Rangarajan case.
My lord, in this case, 1.7 lakh people, my lord, are in the frame, my lord. Now, if my lord, by court orders, my lord, some are allowed to write the exam. And finally, my lord, if they succeed before the KAT and it is held before your lordships now, that order is challenged before your lordships, and your lordships come to the conclusion that the preliminary examination was incorrectly conducted, then the next question that will arise is, what will happen to those who have taken the exam, final exam? Will that be given effect to or not be given effect to? So I'm only saying, Lord, in a large batch like this, whether a person has actually gone to agitate his rights there or no, the lordships may, my lord, take a slightly broader view, my lord, because all these people are not unemployed persons. They have no wherewithal to go to lawyer, all of them, and then go before the court. And they have to prepare for exam. And this, my lord, this examination started, my lord, some 2.5 years ago, my lord. The first time the notification came. Twice, my lord, the examinations were changed and postponed, preliminary itself. Final also, my lord, is in this situation, my lord. So some relief may have to be given, my lord, to.
We are not very sure of our powers in that regard.
May I cite some other case?
Supreme Court
ಇವಾಗ
clarified.
ಟೈಮು ಇಲ್ಲ ತಮ್ಗೆ ಇವಾಗ ಅದು ಒಂದು ಪ್ರಾಬ್ಲಮ್. Unless, my lord, the government says they will postpone the exam. Because your lordships may seem not the preliminary.
Who should take the decision as to postponing of exam?
Government is the
Who is
recruiting.
conducting the, government is only
It
the
is a public
appointing authority.
Public Service Commission, my lords. I'm
Public
appealing for
service-
the Public Service Commission. Any decision has to be by the Public Service Commission. Now I'll just, my lords, after my lords, initially 84 candidates, my lords, had approached the tribunal, the first round of litigation. They had specifically pointed out, we have pointed out certain errors in the key answers and filed objections. Because of this, I am particularly prejudiced because my result will alter based on this. So in respect of those candidates, my lord, the tribunal considered the case, and tribunal also accepted my expert committee report. Only 2 questions which are not referred to were asked to be referred, and which I have done, I have complied. That is a wrong submission that they are making, that I have not complied with the order. Thereafter, matter came before my lords. In 5 of the petitions, where 33 petitioners were involved out of the 84 who had come before my lords, after hearing us, my lords permitted them to write the main examination with certain riders. Now, my lords, thereafter what has happened is, 6 to 7 petitions were filed yesterday. They were listed before the KSAT. We have opposed them, my lords, and today we have taken notice, and it is listed today, my lords, for matter to be heard on the interim prayer.
No, whatever interim prayer is granted here.
Please, my lords.
In all fairness, you should have told the KAT
My lords, it
that
would-
the Honorable High Court has granted interim prayer.
We have informed the tribunal, but I also made a submission to the court that today the matters are listed before my lords. From yesterday, my lords, we took notice yesterday. It is coming up today for hearing on interim prayer. They have cited my lords order before the KSAT.
Correct.
Now here we were under the impression that other persons who were parties before in the original proceedings have come up. But today 5 petitions that were listed, they have never approached the KSAT even yesterday. They have directly come to the High Court.
ಅವ್ರಿಗೆ ಈಗ ಹೋಗ್ಲಿ ಈಗಲೇ ಹೋಗಿ ಅವ್ರು ಹೇಳಿ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತೀವಿ ಯಾರಿಗೆ KAT-ಗೆ. Now kindly take up this matter at 2:30 ಅಂತ.
Yes, one submission, my
One
lord. It
submission.
appears.
One submission, my lords. Yesterday, when the previous orders were passed, my lords, I brought one fact to the notice of my lords. My lords, with regard to the fact, my lords, that the examination is scheduled on Saturday, and my lords had also passed that the main examination results, my lords, will be placed before my lords first. In so far as the performance of the petitioners who will be permitted to take the examination, it will be kept in a sealed cover and placed before my lords. So the ratio 1:15 to 1:3 ratio. 1:15 is a ratio for mains who are now eligible. 1:3 is the next stage. That is the personality test. So basically, I am conducting this main examination for 1:15 to 1:3. So we will be conducting the result on the basis of 1:15 who are qualified, 5,000 people. Now, my lords, I am informed yesterday, my lords, some petitions were filed. There were, I think, 70 to 20. Here, my lords, around 10 people are there. That should not be a problem. But I am informed that now people, this is information I've got, that around 2,000 people are just filing applications now. They are taking signatures, and then people are, and one association, my lords, he is trying to do a padayatra for the purpose of re-examination. So the no, the fact that, my lords, logistically, my lords, I made a submission.
ಹಂಗಲ್ಲ, ಈಗ ನೀವು in all fairness you should have told the KAT.
Please, my lords.
High Court interim order ಮಾಡಿ.
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಂಥದೇ interim order ನೀವು ಮಾಡಿ.
ಇಲ್ಲ, ನಾವು ಅದಕ್ಕೆ ಸ್ವಲ್ಪ
What happened was exactly the opposite converse happened. They opposed it. So the tribunal yesterday has made an order, my lord. This I may read.
ನೀವು immediately ಹೋಗಿ ಈಗ.
ಇಲ್ಲ, ಅಲ್ಲಿ
request the KAT.
My lord, they have made an order to say ಅವ್ರಿಗೆ ಕೊಟ್ಟ ನಿಮ್ಗೆ ಕೊಡಕ್ಕಾಗಲ್ಲ ಅಂತ ಸಿಮಿಲರ್ ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ನಿನ್ನೆ ಆರ್ಡರ್ ಆಗಿದೆ.
I have the instruction, lords, from the council who represented there. Lord, the KPSC took, my lords, time to file objections. Lord, they did not, my lords, want to, lords, give the same benefit. Lord, your lordships, my lords, in Dodaya's case, my lords, has specifically observed that the similar persons, my lords, are to be treated alike.
Lords,
Referring to 1974 Supreme Court
he might be
judgment.
taking instructions from somebody. I appeared before the KSAT. Initially, my lords, my panel counsel was appearing in the matter. We asked for today to receive the copies of the papers to find out, my lords, at least what is their case, and then to come before and then to make a submission today. Then thereafter, my lords, around 5 to 6 counsels, my lords, were insisting, my lords, that the matter be taken up yesterday. Then I was requested. I logged in, my lords. At the end, I said today the matters.
Today those matters have come there.
Today those matters are listed before the KSAT.
ಇವ್ರದಿಲ್ಲ.
Lords,
ಇವ್ರು ಹೋಗ್ಲಿ, ಇವ್ರು ತೊಗೊಂಡು ಹೋಗ್ಲಿ.
Lords,
ತೊಗೊಂಡ್ಬಿಡ್ಲಿಕ್ಕೆ ನಾವು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತೇವೆ.
Friday there is no sitting, Lords. That particular.
No, today.
Lords, today even if we file, Lords, now.
We request the KAT to sit beyond the hours and take up your matters.
Kind leave of the court, my lords. In yesterday's matters, I had appeared before the court, my lords. The order passed by the honorable tribunal yesterday is here, my lords.
ನೀವು ಇಲ್ಲೇ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡೋ ಬದಲು ಒಂದು ಫೋರಂ ಇರ್ತದೆ, ಮುಗಿಸ್ಕೊಂಡ್ ಬನ್ನಿ ಇಲ್ಲಿಗೆ.
ಇಲ್ಲ, ಅವರು ಏನ್ ಹೇಳಿದ್ದಾರೆ ಅಂದ್ರೆ
yesterday, my lord, as your lordships are now expressing, some of us went there and we made an application. Honorable High Court nor ಕೊಟ್ಟಿದೆ ಆ ತರ ಕುಡಿ ಅಂತ. ಅದಕ್ಕೆ they reject that prayer. This is what they say, my lord. These applicants were not parties in earlier appeal. When the applicants who have first time approached this tribunal, whatever interim order granted by the Honorable High Court cannot be extended to these applicants. So application rejected.
No, today it is there. Lords, that is afterwards, let the full order be read. Lords, my submission is recorded that matters are listed today with regard to persons. And today the matters are listed. And my lords, we have, my lords, in so far as allowing persons, our only issues, my lords, will be logistics issues. Because I have yesterday, my lords, already brought it to the notice of the court that the question paper is a 7.
But what you should have said, by going by your stature,
please,
you should have told. Entry ಮಾಡಿದ್ರೆ ಹೈಕೋರ್ಟ್ ನಲ್ಲಿ ಎಲ್ಲೆಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಲ್ಲಿ ಕೊಡಿ ಅಂತ ಅನ್ಕೊಂಡು, ಯಾಕಂದ್ರೆ ಆ ರೀತಿ ಡಿಸ್ಕ್ರಿಮಿನೇಟ್ ಮಾಡಿದ್ರೆ ಹೆಂಗೆ ಇವರಿಗೆ?
Lords, I get, Lords, may I just put it this way? Lords, in fact,
ಅಷ್ಟು ಇಲ್ಲಿ ಬಂದು ಕೂತ್ಕೊಂಡ್ರಿ ಈಗ.
ಇಲ್ಲ, they had already filed petitions here before the petitions there. They filed one sec. Yesterday their petitions were moved at 10:30 for today, my lords. And yesterday the matters were listed there. So some people have approached the tribunal, my lords, in terms of Chandrakumar judgment. Some people have directly come before this court. Now, my lords, we had our my lords, even now, if my lords were considered, I'll just put it out this way, my lords, to be fair to the court and other side also. Even now, my lords, if my lords were to be considering the interim prayer, my lords, the fact that they have to go before the tribunal, my lords, is settled law now. Because Supreme Court in other case said, even a person who was not a party, if he wants to seek review, he has to go there, exhaust his remedy and come here. That is a law. Now, my lords, we were opposing, my lords, the interim prayer in so far as persons who were not originally parties before the earlier proceedings, because they were not aggrieved by the key answers itself. Key answers were published and all of them had challenged the key answers. These people did not challenge the key answers, and the OMR sheet, they know their marks. They were satisfied with that. Now, just because somebody else has got it, my lords, they just want one attempt to write a main examination. My lords, that is our problem.
Yeah, whoever were there,
please, my lords,
ಅವ್ರದ್ದು ಅಪ್ಲಿಕೇಶನ್ ಅನ್ನು ತಗೊಳ್ಳಿಕ್ಕೆ
ಕನ್ಸಿಡರ್ ಮಾಡಲಿ. ಸೊ ಆಯ್ತು,
ನೀವು ಅಲ್ಲಿ ಹೇಳ್ಬೇಕು, ಇದು ಇಂತ ಆರ್ಡರ್ ಮಾಡಿದಾಗ ಅಲ್ಲಿ ಅವ್ರು ಕೊಡದಂಗಿದ್ರೆ ಹೆಂಗೆ ನೀವು ಅಪೋಸ್ ಮಾಡಿದ್ರೆ? But opposition for opposition sake ಮಾಡಿದ್ರಿ.
Not for opposition sake, my lords. It depends on the numbers, my lords. I put it out to my lords. We have certain bandwidth, my lords, to accommodate certain additional things based because question papers are already ready. It is about the logistical issue, my lords, that we are faced with. Now, if suppose, if we concede there, or an order is passed.
ಇಷ್ಟೇ ಹೇಳ್ಬೇಕಿತ್ತು.
2000 ಜನ
ಹೈಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಆಲ್ರೆಡಿ ಗ್ರಾಂಟೆಡ್ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇನ್ ಮ್ಯಾಟರ್ಸ್. ಇಷ್ಟರ ಹೇಳ್ಬೇಕಲ್ಲ ನೀವು ಅವರಿಗೆ.
That was already brought to the notice of the court. My lords, today I consciously made a submission. Today persons who are not parties in the earlier round, our petition ಬರ್ತಿದೆ ಅಂತ ಹೇಳಿದ್ದೀನಿ. So therefore court said ನಾಳೆ ಹೈಕೋರ್ಟ್ will take. If my lords say that let them take a call, my lords, we will go and make submissions.
ಇವರು ಅಲ್ಲಿ ಹೋಗ್ಲಿ immediately.
May I just point out, my lords, only one decision of 2024
holding,
lords, that is under the identical situation. Armed Forces Tribunal, my lords, is concerned. Because the Honorable Supreme Court permits, my lords, that though they have not approved, they are to be given, my lords, the same benefits. My lords, in para number 26.
Armed Forces Tribunal stands on a different footing. There is already a judgment ಅದರ ಮೇಲೆ, ಅದಕ್ಕೆ stands on a different footing. ಇದರಲ್ಲಿ ಏನಾಗಿದೆ, ಇದರಲ್ಲಿ they have said the L. ಚಂದ್ರಕುಮಾರದಲ್ಲಿ ಅದಾದ್ಮೇಲೂ ಬಂದಂತ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ. Even I think that is also considered in that
Dhawan's
case, that is Hemraj Singh Chauhan's case, lords, in 2010.
Correct.
2010.
Correct.
Lords, this is in 2024, lords, considering, lords, the Armed Forces Tribunal's order, which was, lords, not extended in so far as the petitioner is concerned. The Honorable Supreme Court says, lords, instead of dragging each and every one to the court, the same benefit is to be extended.
Ultimately, my lords, we are only, my lords, seeking
No,
mercy of
that
this
what was
honorable
challenged before the court was armed forces tribunals order only.
We have also challenged KT order, my lords.
Huh?
We have
KT
also
order, my lords,
challenged
that we have
KT
challenged.
order, and that is how
We
we
were
are
not
before your
parties.
lordship. Otherwise, we are before the single judgment.
KT order, my
KT
lords,
order is
we have
challenged.
challenged.
KT order challenge ಮಾಡ್ಕೊಂಡು ಬಂದಿದ್ದಾರೆ ಈಗ.
Yes.
Yes.
They are non-party. My lord, what I would like to make submission is, the matter, my lord, is on a matter of principle which applies to all candidates. Now, this is not in relation to an individual. Now, the order passed by the tribunal affects all of us. Now, in a given case where, my lord, individual grievances are different, courts have taken the view you should first go there and come back. There is no point in going there because the issue is before your lordship. Your lordship has seized the entire matter. Now we have to go there, get it dismissed, and then come back to here. Apart from that, my lord, nothing is going to be. Sir, examining the total system of this manner in which this examination is sought to be done. So that being so, the tribunal has already given a finding that expert committee should look into it. We do not know what has happened to the expert committee. We could have got ourselves implicated in this case also because we are also affected. Instead of that, my lord, we have filed an independent petition where your lordships are already examining the correctness of this order to call upon us to go there and then get an order, then come here, my lord, would serve no purpose. In fact, my lord, your lordships are aware of this doctrine of useless formality, unnecessarily going there. Your lordships are examining the correctness of this. Now we are all bound by whatever your lordship say, Lord, we are all bound by it.
Suppose
Now,
if the already pending petitions are allowed,
yes,
will you be
then,
benefited?
my lord, all of us are affected. Now your lordship
Benefited or not?
Yes, all of us will be affected.
Leave it then.
It will apply to all of us.
If that is so, why, where is,
So therefore, my lord, we are also right. We want that our voice also should be heard by your lordship because ultimately your lordships are taking a view which affects all the candidates. Now we are before the court so that our grievances are also heard because your lordships are already considering the matter. One matter, my lord, now this preliminary examination got postponed nearly 4 times. What I would humbly request is, let them, my lord, defer it for some time, kindly examine it, give a final decision, let us know because of the background in which this KPSC is functioning, my lord. It appears, I don't know, I'm not competent to say, some of the members of the KPSC are retiring, so that is why, my lord, this extraordinary hurry. ಇವ್ರಿಗೊಂದು ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಮಾಡಕ್ ಬರಲ್ವಾ ಕನ್ನಡದಲ್ಲಿ? ನೀವು ಕನ್ನಡದಲ್ಲಿ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡ್ಬೇಕು ಅಂತ ನೀವು ಹೇಳ್ತೀರಾ, ಇವರಿಗೆ ಕನ್ನಡ ಮಾಡಿದ್ದಾರೆ. ಸರ್ ಇದನ್ನೆಲ್ಲ ಎಕ್ಸಾಮಿನೇಷನ್ ನೀವು ಕ್ವಶನ್ಸ್ ನೋಡ್ಬಿಟ್ರೆ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ. ಇಟ್ ಇಸ್ ಶಾಕಿಂಗ್. ಇವರು ಕನ್ನಡದಲ್ಲಿ ನಾವೆಲ್ಲ ಕನ್ನಡ ಆಡಳಿತ ಭಾಷೆ ಅಂತ ಹೇಳ್ತೀವಿ, ಇವ್ರು ಟ್ರಾನ್ಸ್ಲೇಟ್ ಮಾಡಿದ್ರೆ ಜುಡಿಷಿಯಲ್ ರಿವ್ಯೂ
argument on the merits itself, lords, we are ready on the
ರಿವ್ಯೂ
merits.
ಅಂತ ಹೇಳ್ತಾರೆ. ಜುಡಿಷಿಯಲ್ ರಿವ್ಯೂಗೆ ಸ್ಥಾನಿಕ ಪುನರಾವಲೋಕನ ಅಂತ ಹೇಳ್ತಾರೆ. ಸ್ಥಾನಿಕ ಪುನರಾವಲೋಕನ. ಯಾವ ಜುಡಿಷಿಯಲ್ ರಿವ್ಯೂ ಸ್ಥಾನಿಕ ಪುನರಾವಲೋಕನ ಅಂದ್ರೆ ಏನು?
Insofar as the merits of the matter, lords, we have been able to persuade the tribunal, lords, on the basis of the expert report. It was only 2 questions. Let them not go on the merits of the matter, lords. If on the last date of hearing, lords, I also made a submission when, lords, the other batch was arguing. Lords, initially they were not happy with an order to take the examination. There is an attempt to sabotage the examination. There is an attempt to sabotage. They want just to postponement. Please, lords.
ಈಗ ಹಾಕಿದಂತ ರಿಟ್ ಪಿಟಿಷನ್ ಅನ್ನು ನಾವು ಅಲೋ ಮಾಡಿದ್ವಿ ಅಂತ ತಿಳ್ಕೊಳ್ಳಿ.
Please, lords.
ಕಾನ್ಸಿಕ್ವೆನ್ಸ್ ಏನು?
Lords, my lords will decide 2 things. The moment I place, my lords, the final
ಇಷ್ಟೇ ನಮ್ಗೆ ಪ್ರಶ್ನೆ ಸಿಂಪಲ್. ಅಲೋ ಮಾಡಿದ್ವಿ ಅಂತ ತಿಳ್ಕೊಳ್ಳಿ. We set aside the order of the KT ಅಂತ ಇಟ್ಕೊಳ್ಳಿ. ಅದರ ಇಂಪ್ಯಾಕ್ಟ್ ಏನೇನಾಗ್ತದೆ?
My lords will be first considering whether if they're eligible, my lords, to be heard on the merits of the matter based on.
We'll assume that we reject all your contentions.
Please,
accept all their contentions.
Lords,
What will be the effect of allowing of the application, allowing of the petition, quashing the order of the tribunal? Other consequences?
No, only if my lords were just asking a theoretical question.
Theoretical, that either this way or that way.
This way or that way. No, subject, if main examination is held and at that stage, my lords were to hold preliminary examination, my lords, was bad in law, then my lords have to balance the equities. That is a different aspect of the matter. But, or a re-examination also could be ordered. But at the same time, my lords, we have succeeded before the tribunal in the first round of litigation. And my lords, if my lords, I want to make this submission. My lords have asked me, you could have made a fair submission before the tribunal also with regard to the the fact that High Court has granted an interim order, why not extend this interim order? My lords, yesterday, my lords, we were not even served with the copies. We were informed that the matter was there. The panel counsel was requesting for the copies to be taken up today because of the, my lords, if I am making a submission, my lords, on behalf of the commission, that if it is a manageable number, my lords, even in respect of the petitioners, we can hold the examination. But I am informed. In fact, my lords, I take the liberty because they are saying about this. Morning, my lords, my learned friend Prithvish is there. I am just taking liberties, my lords, to make the submission. I am informed that now people are just taking the signatures of 2,000, 3,000 people on wakalats. No, the people who are before the court, my lords, certainly we can, if it is a manageable number, I can accommodate. I can certainly accommodate. I made.
Yes, Chennai.
There is an entire room set up for this. I'll just point out. Parking nodbekittu. I'm sorry, I should not say this. There was an entire room set up, not saying, not.
ಒಂದು ರೂಮ್ ನಾಗ ಕುತ್ಕೊಂಡು ಎಲ್ಲ ಸೈನ್ ಮಾಡ್ಕೊಂಡು ಕೊಟ್ರೆ ನಾವು ಒಂದೇ ರೂಮ್ ನಲ್ಲಿ ಕುತ್ಕೊಂಡು ನೀವು ಸೈನ್ ಮಾಡಿರಿ
Not that, not. It's an attempt to sabotage.
I can watch, my lords, everybody has come to my office and signed before.
But I can tell.
ನಮ್ಗೆ ಅದು ಗೊತ್ತಿಲ್ಲ.
Not the persons who have come. Lords, he is a good friend of mine. He is a very respected counsel. No, we are good friends. There is no doubt about it. I just, my lords, took the liberty because since lot is being said, I just wanted to, lords, if it is a manageable number who are before the court as of, there has to be
manageable number ಅಂದ್ರೆ ಏನು ಅಂತ.
Lords, I would put it this way. Suppose the persons who are before the court as of now, before the tribunal and before my lords, if we permit them, then my lords, I think we will be able
Yes,
to. It might come to around 50 people. Let us assume. Now I am told, if my lords put a cutoff that in respect of any further petitions that is being filed before the KSAT or before my lords, no further permissions will be granted because I don't have time to 3 days time, my lords, to do the main examination. My lords, KPSC will agree for that. KPSC will agree. I am making a submission as on today, but I am told, my lords, another 200. There is one more petition filed with 200 people
waiting.
1,000 people waiting.
1,000 people are waiting for this. They want to sabotage the exam. That is all.
If my lords,
ಅಂದ್ರೆ ಇದು ಹಾಸ್ಪಿಟಲ್
time is the issue there. They're sitting. They're sitting on the fence, waiting that this order could be passed, and then they're moving it in bulks and batches, just not to write the exam. If their bona fides was to write the exam, from January they could have done something. They are coming before this court just 3-4 days before the exam. All this activity has started 10 days before the exam. Your lordship are looking at it.
Who are you?
No, I'm the successful candidates. I filed my application, it's on record. No, what is going to happen is, I have been preparing for the exam since January. Now, look at the uncertainty which hangs over the head of these successful candidates having qualified. I just point out, amongst all those wrong answers also, I have chosen to return the correct ones after great difficulty of whatever they are saying, which means meritoriously, we are much better.
Their IA
ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ?
about 100, maximum 100 here. 60 plus about.
Lords, before the tribunal, there are around 17, total 5 applications, around 17 applicants to 20 applicants maximum, whose petitions were listed yesterday and listed today, and then again today also they moved it for 2:30. So they are covered. Now, my lords, before my lords, there are 7 petitions, 5 petitions today listed. I think yes,
75 to 80 of us. 75 to 80.
Senior advocates argue ಮಾಡುವಾಗ yes,
about 75 to 80 of us right now before your lot.
Let them give a number.
There are around 11 people. There are 11.
ಎಷ್ಟು ಜನ ಅರುಣ್ ಶರ್ಮಾ ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ?
ನಮ್ದ್ರಲ್ಲಿ ಒಂದೇ. Yesterday we moved before the KT Milord. KT Milord didn't grant interim order, so we moved for the end of the list.
Adhan, that also is included. I'm telling, including that also, which were yesterday, my lords, which are listed before the KSAT, which are relisted today, where some of them have already come to the court, and petitions which are listed as of now. If my lords can, even my lords, without saying that it is a precedent that tomorrow it should not be. I don't have any objection, my lords, to if it is a manageable number, my lords. I'm just putting it out because my only apprehension is this.
Manageable number ಅಂದ್ರೆ ಅಂದಾಜು ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ?
My lords, we had made arrangements, my lords, for the original 84 also. 84 original applicants idru. Earlier 33 people my lords had permitted. Innondu 50 jana. ಈಗ ಸದ್ಯಕ್ಕೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇರೋದು 50 ಜನನೇ. ಈಗ ಮುಂದೆ now there, suppose my lords granted by from now onwards till the end of the day or my lords on Friday, there could be another 2,000 to 3,000 or 5,000 people.
ಫ್ರೈಡೆ ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ನಿಮ್ಗೆ ಸ್ಯಾಟರ್ಡೆ ಇದನ್ನ ಮಾಡಕ್ಕೆ ಹೆಂಗ?
ಈಗ ಮಾಡಕ್ಕೆ ಆಗಲ್ಲ. ಅದಕ್ಕೆ my lords, I am straight away putting it out, my lords. If my lords were to give a cut off for me, then my lords, without insisting on any formalities with regard to my lords, the fact that they have to go back to that court, I can, my lords, we can manage it.
ಎಷ್ಟು ಜನರನ್ನ ನೀವು ಅಕೊಮೊಡೇಟ್ ಮಾಡ್ಬೋದು ಈಗ?
Milords, who, all the persons whose petitions are listed today before KSAT and before the High Court.
ಏನೇನ್ ಮಾಡೋದಿರ್ತದೆ ಎಕ್ಸಾಮಿನೇಷನ್
Examination
ಪ್ರಿಪರೇಷನ್ ಅಂದ್ರೆ
there are two-
ಕ್ವೆಶ್ಚನ್ ಪೇಪರ್ ಪ್ರಿಂಟ್ ಮಾಡೋದಿರ್ತದೆ.
No, Milords, we have total of 7 papers, including 2 compulsory papers and 4 general studies, 1 optional paper. It is a descriptive type questions. And the answer booklet, Milords, is a question paper come answer booklet with separate barcoding, because ultimately it's about barcoding, because identification of the persons has to be at the time of valuation. So ಏನಂದ್ರೆ ನಮ್ಮ ಹತ್ರ extra question paper booklets ಇರುತ್ತೆ usually. ಈ ಕೇಸಿಗೆ I had made a submission that we will, despite in respect of petitions who are not before the court also, we will make some arrangements. I had made a submission on the other day. And according to that, Milords, around 84 and 100, let us assume 100 people, Milords, we can manage it. And right now interim order is only for 33 people. Another 30 people might be before my lords, before KSAT and before this court.
Here 80 are here, about 20 there right now. So
Milords,
about
if
100.
if that cutoff is there, Milords, my only worry is there should not be any another
floodgates
open agilla andre,
Open
Milords,
up.
I am totally, Milords.
ಅಲ್ಲ ಈಗ ಯಾರು ನಮ್ಮ ಮುಂದಿದ್ದಾರೆ ಈಗ ಅವರು
list ಮಾಡಿ.
ಒಂದು ಲಿಸ್ಟ್ ಮಾಡ್ರಿ ಮೊದ್ಲು,
I'll give.
ಆಯ್ತಾ? ಲಿಸ್ಟ್ ಮಾಡಿದ ನಂತರ ಮುಂದೆ ಆಮೇಲೆ ಬರುವಂತವ್ರಿಗೆ ಏನಿದೆ ಲಾಸ್ಟ್ ಮೂಮೆಂಟ್ ಗೆ ಅರೇಂಜ್ಮೆಂಟ್ ಮಾಡೋದು ಡಿಫಿಕಲ್ಟ್ ಆಗ್ತದೆ. ಹಾಗಾಗಿ ಆ ಡಿಫಿಕಲ್ಟಿ ಮೇ ಬಿ ಎ ಗ್ರೌಂಡ್ ವಿಚ್ ಮೇ ಪ್ರಾಂಪ್ಟ್ ಅಸ್ ಟು ಅಕ್ಸೆಪ್ಟ್ ಯುವರ್ ಕಂಟೆನ್ಷನ್.
Please.
So far as granting of not granting not ಏನು ಯಾರ್ಯಾರು ಇದಾರಲ್ಲ
Please,
ಅವ್ರೆಲ್ಲರಿಗೂ ಇನ್ನು ಉಳಿದಂತವ್ರಿಗೆ ನೀವು ಕೊಡೋದ್ರಿಂದ
please.
ಏನಾರ ತೊಂದರೆ ಆಗ್ತದ ನಿಮ್ಗೆ?
ಇಲ್ಲ ಇಲ್ಲ, my only thing is about logistics, because at the end of the day 1:3 is going to be determined only on the basis of existing qualified people. Amel will place it before my lords. If they are qualified, idea of preliminary examination is to write a main exam. If you are writing a main examination, if you come within the cutoff, my lords, then they are entitled, then their petitions could be considered. My lords, we could, if with the serial numbers, I have the list, we can file a list before the petitions listed before KSAT with serial numbers, number of applicants. Illi ya serial number with number of applicants. I'm told 230 gana move madidare. Few matters had moved for 230. Even, my lords, considering that, if my lords could put a cutoff for me.
230 ಗೆ ತೊಂಬೋಣ,
ಆಯ್ತು
ಆಯ್ತಾ? ಅವಾಗ ಎಷ್ಟು ನಂಬರ್ ಅಂತ ಗೊತ್ತಾಗ್ಬಿಡ್ತದೆ.
Please.
ಆಯ್ತು.
Only one submission.
Our only problem is, Milords, it is, Milords, our only, I made a submission on the other day also. Booklets are getting opened.
Today, this examination.
ಅಲ್ಲ ಇಲ್ಲಿ ತಾವು ಅರೇಂಜ್ಮೆಂಟ್ ಮಾಡಿದ್ರೆ KT ಇದು ಅದನ್ನು ಇಟ್ ಸಬ್ಸ್ಯೂಮ್ಸ್.
ನೀವೇ ಹೇಳ್ಬಿಡ್ಬೋದು.
ಅಲ್ಲಿ ಹೇಳ್ತೀನಿ, ಐ ವಿಲ್ ಟೆಲ್ ದ ಕೋರ್ಟ್ ದಟ್ ಮೈ ಲಾರ್ಡ್ಸ್ ಆರ್ ಸೀಸ್ಡ್ ಆಫ್ ದ ಮ್ಯಾಟರ್, ಜಸ್ಟ್ ಡೆಫರ್ ಇಟ್ ಅಂತ ಹೇಳಿ.
ಅಲ್ಲ ಡೆಫರ್ ಯಾಕೆ?
ಅಲ್ಲ ಇಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡಿ ತಾವು ಮಾಡ್ತೀರಾ ಆರ್ಡರ್
ಇಲ್ಲಿ ಅಲ್ಲಿ ಡೆಫರ್ ಆದ್ರೆ ಅವು ಆರ್ಡರ್ ಇಲ್ಲಿ ಬರೋವರೆಗೆ
ಇಲ್ಲ. My lords can pass one generic common order, my lords, including the I'll give numbers of the cases.
List can be given, Milords, list can be given with the name.
ಇಲ್ಲ ಅಂದ್ರೆ ಅಲ್ಲಿ ಪಾಸ್ ಓವರ್ ಕೇಳ್ತೀವಿ.
This exercise is going to become futile, because if only your lordship sees the order of the KAT,
then we will be able to say.
This is, Milords, the exact point what we were trying to.
Why are you interfering? You have been heard enough now. Yes.
They have specifically recorded, looking at the questions, to say that what this preliminary examination cannot be accepted. They have come to that conclusion on facts, not only questions on which objections were there, other things also. And, my lord, at the end of it, they say this has to be redone.
We don't know.
No, that
is your stand. Anyway, you are briefed to say that is another thing.
Such a large number of students, Lord, who are now going to take the examination.
ನೀವು ಮಾಡಿದ ತಪ್ಪಿಗೆ ಸಮಸ್ಯೆ.
ಅಲ್ಲ, ಅದಕ್ಕೆ
one subject KT, my lord, sits till 2
vacation
PM.
ನಂತರ ಹಾಕಿದ್ರೆ examination, my lord, what I'm saying is this recruitment, my lord, started in 2024.
ಇಲ್ಲ, ಎಕ್ಸಾಮಿನೇಷನ್ ನಾವು ಸ್ಟೇ ಮಾಡ್ಲಿಕ್ಕೆ ಎಷ್ಟಿದೆ ಬೇಕು ಅಂದ್ರೆ ನೀವು ಎಲ್ಲರೂ ಯಾರ ಪೇರ್ ಅದನ್ನ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ
postpone ಮಾಡಿದ್ರೆ,
ಪೋಸ್ಟ್ಪೋನ್ ಮಾಡೋದು ನಮ್ಗೆ ಡಿಫಿಕಲ್ಟ್.
KT sits till 2 PM. We'll seek for a pass over there. My lords may take it at 1 PM, my lords. Yakan astrology we can.
1 PM there's a bench, 2:30 only. 1 PM there's a
Come
bench.
back by 12:30 minutes.
12:30. All right, we'll call them at 12:30.
12:30. And my lords, this 2:30 matters, ಅದನ್ನು ಬಂದ್ಬಿಟ್ರೆ ಅಥವಾ ಅವರು ಡೀಟೇಲ್ಸ್ ಕೊಟ್ರೆ will.
ನೋಡಿ, ಆ 2:30 ಮಾಡಿದಂತದ್ದೆಲ್ಲ ತರಿಸಿ.
ಅದು KPS.
ಅಂದ್ರೆ ಅವ್ರ ನಂಬರ್ ಏನು ಅಂತ ಗೊತ್ತಾಗ್ತದೆ ನಮ್ಗೆ at least.
No, all the petitioners are here.
ಎಲ್ಲರೂ
FR number. FR number.
12:30 FR ನಂಬರ್ ಇದೆ, ಹೆಂಗಿದೆ ಅಂತ ಬಂದ್ಬಿಡಿ. ಅಲ್ಲಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅನ್ಕೊಂಡು ಇಡೋದು ಬೇಡ, ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಜೊತೆನೆ ಬರ್ಬೇಕು.
I will request the KSAT to pass over the matter so that ಅಲ್ಲಿ 2 o'clock ತನಕ ಕೂತ್ಕೊಂಡು their sitting is still 2.
ಅಲ್ಲ, ಅದು ಪಾಸ್ ಓವರ್ ಯಾಕೆ? ಅಲ್ಲಿ ಆಲ್ರೆಡಿ ಆರ್ಡರ್ಸ್ ಮಾಡಿದ್ದೀವಿ ನಾವು.
Please, my lords.
They could follow the same order.
ಆರ್ಡರ್ ಫಾಲೋ ಮಾಡಬಹುದು. We are thinking that way.
No,
We leave it to your wisdom, because that matter is not before us. We cannot preempt
ಇಲ್ಲ ಅವರು ಇಲ್ಲಿ ಬಂದಿದ್ದಾರೆ, ಅವ್ರದ್ದು 230 ಮೂವ್ ಮಾಡಿದ್ದಾರೆ. ಅಂದ್ರೆ ನೆನ್ನೆ ಎಂಟ್ರಿ ಮಾಡರ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಔಟ್ ಆಫ್ 5 people, I think 2 people have come before. Before this honorable.
At 2:30.
12:30. 12:30. Grateful.
ಈ ಎಕ್ಸ್ಪರ್ಟ್ ಕಮಿಟಿ ರಿಪೋರ್ಟ್ ಅವ್ರದ್ದು ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅನ್ನೋದು
ಅದು
ಗೊತ್ತಾಗ
ಹೇಳಿದ್ರು ಅವರು ಎರಡು ಕ್ವಶನ್ ಅಷ್ಟೇ ಹುಟ್ಟಿದ್ರಂತೆ. ಆ 2 ಕ್ವಶನ್ ಗೆ ಎಕ್ಸ್ಪರ್ಟ್ ಕಮಿಟಿ ಫೌಂಡ್ ದಿ ಸೊಲ್ಯೂಷನ್ ಅಂಡ್ ದೇ ಹ್ಯಾವ್ ಅವಾರ್ಡೆಡ್. ನೋಡೋಣ 12:30ವರೆಗೆ. That's what.
Grateful.
All.
There is one other submission. Can we make it at 12:30? Yes.
11.
10. But I appear for the petitioner. Lord, the petitioners were, my lord, placed under Rule 32 to the cadre of, my lord, First Division Assistant on 7/11/2019.
7/11/2019.
Lord, DPC was held. In the DPC, my lord.
When it was held?
On 7/11/2019.
Then they, as on that date, they were not holding any post at all.
Lord, the DPC was held on 7/11/2019.
Correct.
On the same day, promotion order is given.
To them.
Not promotion, my lord. Rule 32 arrangement.
Rule 32 arrangement.
Yes.
Independent charge.
Independent charge. Lord, DPC takes note of the request of, my lord, Special Land Acquisition Officer, KADB, and, my lord, in the Department of Food and Civil Supplies. The vacancy which are available in those, my lord, departments, on their request, my lord, we have been placed under Rule 32. Lord, you know, the state government, my lord, is sought to withdraw the promotion on the ground that, Lord, in the department, there are no vacancies. We are working for the last 6 years.
As against the vacant position?
Yes, my lord, vacant position. In the
What is that?
vacancy available?
Rule 32. They have been working since last 6 years. Which are then? Huh? No, SD. Eligible persons means? But for 6 years, they have been holding the post. And the provision says we have held that if at all they are promoted, it should be with retrospective effect. Even that benefit they will lose. Correct. They are available. Huh? Illa.
First Division assistants
Where is your reply statement? Show that. Where have you taken up that contention? If you have taken up that contention, perhaps that's a very good ground for you. Where have you taken up that contention? ಅಲ್ಲ ನಿಮ್ ರಿಪ್ಲೈ ಸ್ಟೇಟ್ಮೆಂಟ್ ನೇ ತೋರಿಸಿ ಎಲ್ಲಿ ತೊಗೊಂಡಿದ್ದಾರೆ, ಎಲ್ಲಿದೆ ರಿಪ್ಲೈ ಸ್ಟೇಟ್ಮೆಂಟ್?
ರಿಪ್ಲೈ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲ, my lord.
ಹಾಕಿಲ್ಲ. ಇದೇನು ಇಂಟ್ರಿ ಆರ್ಡರ್ ಮೇಲೆ ಬಂತ ಫೈನಲ್ ಆರ್ಡರ್ ಮೇಲೆ?
Against interim order, the tribunal says stay cannot be granted. But we are
6 years they have
6 years we are working.
6 years they have, no, you can't do that. Berkali, issue emergent notice. Learned AGA is requested to accept notice for the respondents. Interim order as prayed for. ಏನಂತ ಕೇಳಿರಿ interim order?
Stay of, my lord, annexure A7.
Stay of annexure
A7
dated
28/3/2025.
ಎಲ್ಲರಿಗೂ
ಹೌದು.
28/3/2025, which is put in challenge before the
tribunal
pending application numbers 1256 ನಿಂದ 1259 of 2025 is pending on the file of the Karnataka State Administrative Tribunal till the next date of hearing. First off, this interim protection has been accorded on the vehement submission of learned counsel for the petitioner that his clients have been working under Rule 32 since more than 6 years, since about 6 years. Okay. ಅದು ಸುಳ್ಳಿದ್ರೆ ಕೇಸ್ ಹೋಗ್ಬಿಡುತ್ತದೆ.
I have produced. Lord, the only one office objection is, my lord, there were 4 applicants, 3 of them have come, 1 is not arrayed as a party. That has no
objection overruled. Yes.
Petitioners are calling question
the notice issued under the, by land grabbing code. My lord, we are the owners of sites in survey number 44.
Date of sale deed ಹೇಳಿ.
My lord,
9821, it is post act.
now say my sale deed is dated.
9821 ಇದೆ.
Yes, my lord.
Post act ಇದೆ. You apply for discharge under 227, they will consider, we will exempt you from.
Only one submission. On an earlier occasion, the same survey number, they said it is government land. I produced all the documents. The proceedings were dropped. Now, annexure G page 74, 75. First time I drop ಮಾಡ್ತಾರೆ. Now they are telling this is not in 44/2, it is in 44/1 ಅಂತಾರೆ. Annexures page, annexure G 72 and 73 page number, my lord. Dated 4/10/2023. All the sale deeds, everything I produced, drop ಮಾಡ್ಬಿಡ್ತಾರೆ. ಮತ್ತೆ ಇನ್ನೊಂದು
Hey brother, come to page 73, read the last paragraph. ಅಲ್ಲ ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಹೋಗಿ, ಅದೆಲ್ಲ ಆದ್ಮೇಲೆ ಬರ್ತದೆ. ಜೋರಾಗಿ ಓದಿ, ಮೈಕ್ ನಲ್ಲಿ ಓದಿ, ನಮ್ಗೆ ಕೇಳ್ಬೇಕು ನಿಮ್ ವಾಯ್ಸ್, ಬೇರೆಯವ್ರಿಗೂ ಕೇಳ್ಬೇಕು. ಓದಿ.
ಈ ಮೇಲಿನ ಎಲ್ಲ ಅಂಶಗಳನ್ವಯ ಸದರಿ ದೂರಿನ ಅರ್ಜಿಯ ವಿಚಾರಣೆಯನ್ನು ಮಾನ್ಯ ಮೇಲಧಿಕಾರಿಗಳು ಅನುಮೋದನೆ ಪಡೆದು ಮುಕ್ತಾಯ ಮಾಡಿ ವರದಿಯೊಂದಿಗೆ ನಿವೇದಿಸುತ್ತೇನೆ.
ಅಗೇನ್ ಒನ್ ಮೋರ್. ಸುಮ್ಮನೆ ಬರ್ಕಡ್ರಿ. ಇಶ್ಯೂ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್. Learned AG is requested to accept notice for respondents 1 and 2. Interim order as prayed for till next date of hearing. This interim protection has been afforded, keeping in view the operative portion of the proceedings at annexure G.
Yes, please.
Page 72, 73 of the petition.
Grateful, man.
Petitioner.
Yes.
In light of my lord's Shivdev Singh judgment, the writ petition is please. It is more in the nature of a review because I was not a party, my lords, before the division bench. At page
63, 64 Supreme Court.
Please.
In ನಿಮ್ಮ land ಮೇಲೆ
Yes, what was offered was my land before the division bench. At page, my lords, 26 is the proceeding. At page 27 is the order. 26 is the
maintainability
case status.
Issue of maintainability pales into insignificance in view of apex court decision in Shivdev Singh versus state of
Punjab.
State of Punjab. Year 1964 Supreme
63
Supreme Court
1909.
1909. ಇಲ್ಲಿ ತೋರಿಸಿ ನಿಮ್
At page 27, my lords.
27.
I had no concern with the public interest litigation which was pending. I had no concern. My land had nothing to do with it. At paragraph 3,
No.
if you.
No.
Please.
If it is a public interest litigation, then courts have taken the view, those orders are orders in rem.
Please.
In other words, res judicata applies to non-parties also, though not rem.
Only if your lordship sees para 2 at page 27.
Para 2.
At page 27.
See,
The present application is moved by the learned additional government advocate that the plan to construct a school and a primary health center, although remains, the lands in which such constructions were to be undertaken have been found to be unsuitable by the structural engineers. A report of the said engineers is also produced along with the application. Learned additional government advocate submits that the permission be accorded for construction of a primary health center in 6 guntas in survey number 21 of so-and-so village and a primary school in 25 guntas of so-and-so village, both in Bangalore South Taluk only, instead of the earlier designated land in survey number
58 of Gollahalli.
Please,
This 21 one belongs to you.
Please.
ಎಲ್ಲಿದೆ ತೋರಿಸಿ.
At, my lords, at page 50, in the year 1997 itself, there was a grant in my favor.
50.
Please, my lords. And all the proceedings, my lords, at page 69, if your lordship sees, is the sketch, which will give a clearer picture.
ದೇವಸ್ಥಾನ.
Please, it's a temple.
ಎಂತ ಏನ್ ಟೆಂಪಲ್?
This is, my lords, Maheshwaramma Chamundeshwari temple. And all the proceedings that have transpired before filing of the IA, my lords, nothing was brought to my notice. I did not participate in anything. Although, my lords, I have to admit that the official memorandum wherein the land was granted for the purpose of this PIL, my lords, that came to be challenged by me in a separate proceedings before the KAT. Because of the division bench order, my lords, KAT dismisses my petition, against which I came before this honorable court. I have challenged it by way of a writ petition. There I had initially got an order of stay. That stay, my lords, came to be vacated because of the this order. Now, wherever I go, my lords, this order is coming in the way. Therefore, my prayer is at page 22 in this petition.
ಈಗ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಈಗ ಅಲ್ಲಿ ಆ ಜಗದಲ್ಲಿ?
Now, my lords, at if your lordship sees page 156, they are proceeding with this, some sort of status quo order, my lords, so that they don't do anything.
156.
Please, my lords. I have produced the photos there.
ಮತ್ತೆ ಇಷ್ಟೆಲ್ಲ ಮಾಡಕರಿ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
ಇನ್ನೇನು ಇಲ್ಲ. I have been running from pillar to post, my lords. I had a benefit of a stay for a long time. The interim order got vacated on 14th of March this year.
14/3/25.
Please, I have produced that also, my lords.
ತೋರಿಸಿ.
Annexure Y, my lords, page 148.
You were not party to that PIL.
No, my lords. And because it came in the form of an IA, that they said that the land has to be substituted. Initially, they identified.
Correct. ಯಾಕಂದ್ರೆ 2% ಅಮೌಂಟ್ ಕಲೆಕ್ಟ್ ಮಾಡಿಕೊಂಡಿದ್ರು ಕಟ್ಟಬೇಕು ಅಂತ ಮಾಡಿದ್ದು ಅಷ್ಟೇ.
ಹೌದು. At page 148, your lordships will see.
What do you say, brother? ಅವ್ರ ಲ್ಯಾಂಡ್ ಮತ್ತೆ ನಮ್ಗೆ ಯಾರಾದ್ರೂ ಹೇಳಿದ್ರೆ ನಮ್ಗೆ ಗೊತ್ತಾಗ್ತಿತ್ತು. ಅವ್ರಂದ್ರು ಈ ಲ್ಯಾಂಡ್ ಬೇಡ, ಈ ಲ್ಯಾಂಡ್ ಬದಲು ಇಲ್ಲಿ ಕಟ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು, ಆಯ್ತು ಕಟ್ಟಿ ಅಂತ ಹೇಳಿದೀವಿ ನಾವು. ಎನಿವೇ ಸ್ಟೇಟಸ್ ಕೋ ಮೇಂಟೈನ್ ಮಾಡಿ ಅಲ್ಲಿವರೆಗೆ. ಸ್ಟಾರ್ಟೆಡ್ ಅನ್ಲಿಕ್ಕೆ ಈ ಮೂರು ಇವನ್ ನಿಲ್ಸ್ಯಾರ, ಏನು ಪಿಲ್ಲರ್ಸ್ ಅಲ್ಲ, ಐರನ್ ರಾಡ್ ಅನ್ನು ನಿಲ್ಸ್ಯಾರ ಅಷ್ಟೇ. ನೋಡಿ, ಇಶ್ಯೂ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್. ನಿಲ್ಸಿ, ಅದು ಇನ್ನೊಬ್ರು ಲ್ಯಾಂಡ್ ಹಂಗ್ ಮಾಡಕ್ ಬರ್ತದ? ಅದು ಟೆಂಪಲ್ ಲ್ಯಾಂಡ್, ಅದು ಪಾಸ್ ಓವರ್. ಎದಕ್ ಪಾಸ್ ಓವರ್? ಅಲ್ಲ, ಇವನ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ಯು ದಿಸ್ ಇಸ್ ದ ಲ್ಯಾಂಡ್ ಬಿಲಾಂಗಿಂಗ್ ಟು ದಿ ಟೆಂಪಲ್. ಹೇಳಿ, ಪಾಸ್ ಓವರ್. ಗ್ರೇಟ್. ಅವ್ರು ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ, ಪಾರ್ಟಿ ಮಾಡ್ದಂಗ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. ಪಾಸ್ ಓವರ್.
Disciplinary authority conduct department inquiry.
Rule 3.
Disciplinary authority conduct department inquiry and charges were proved, lordship.
Lord, outside the purview of the
post penalty or dismissal.
2018 matter after vacation.
Please.
Last occasion, my lord, your lordship directed them to pay the money for the.
Lord, in all these matters, the issue relates to those who were appointed as Group D employees in the various departments of the government. My lord, these matters relate to the police department, where they were appointed initially on contract basis. Thereafter, after they completed 10 years, they were accommodated against post which was permanently created, but it was a non-pensionable post.
Yeah.
My lord, what has happened is in
Where is
some.
that, the post created is non-pensionary in Telitoris?
My lord, sorry to interfere, my lord. This matter has been moved by me. They have connected other two matters, which is one is irrelevant.
Anyway, after vacation told.
No, my lord. The submission is why I have moved it. Last occasion, your lordship directed them to pay the money to the people who are working on the contractual basis at least. These are the list of the people whom they have not paid. That is the reason I moved the matter, my lord. The other connected matter has not been
They
moved
have
by
not been paid since how long?
The interim order, 2020, the interim order, 2021, the interim order, which last
2021.
week your lordship has given a direction.
Call this matter immediately after vacation.
My lord, direction may be.
Yeah, next.
I'm for petitioner in this case, my lord. To filing online filing also 2 days delay ಆಗಿದೆ my lord ಇದರಲ್ಲಿ.
ಯಾವುದು? ನೋಟಿಸ್ ಹೋಗಬೇಕಾಗತ್ತ ನಾವು.
Issue emergency notice to
Emergent notice.
cell number 22 also.
22?
My lord.
Same.
Yes, my lord.
Yes.
Appearing for the petitioner, I filed an IA, your lordship. The only urgency is this, your lordship had granted an interim order in this matter. Now what the state has done is they've amended the rules and they've passed the seniority list, which whereby the junior officers have been made. I may just take your lordship to my IA, your lordship. As of
Call this matter in terms of order dated 26/3/2025. Okay.
your lordship, the amendment may be state that.
There's already order. Yes, next. Interim order to continue, earlier interim order to continue. Okay. Yes, Ashoka.
Based on my lord's suggestion, both the parties have reached an amicable resolution, my lord.
Yeah, no.
We want to report, we have filed IA 1 of 25, my lord. Parties also before, my lord. This is that arbitration matter. This is that arbitration matter before the learned sole arbitrator. My lord is pleased to direct us to advise the parties to reach a.
This is a matter where there are some allegations on the tribunal, and my lords were pleased to request Shankar sir to initiate.
Yes.
That where Ruben
How
sir
it
appeared
is
for me.
amicable
ಅವ್ರ ಹತ್ರ ಹೋಗಕ್ ಮುಂಚೆನೆ settle ಆಗೋಯ್ತು ಸ್ವಾಮಿ. The parties sat together and.
ಶಂಕರ್ ಅವ್ರ ಹೆಸರು ಕೇಳಿದಕ್ಕೆ ಕೆಲವು ಕೆಲಸ
Yes, that's what I told learned senior counsel. His blessings to the settlement has.
But we have informed him that it got settled also. Even
But
he was
still,
happy.
because we appointed
my lord,
him
yes,
as the,
we bowed
therefore
down.
you have to make the payment.
Yes, yes, absolutely.
ಕೆಲವ್ರ ಹೆಸರು ಕೇಳಿದಕ್ಕೆ ಸೆಟ್ಲ್ ಆಗ್ತದೆ.
Yes, yes.
ಅದಕ್ಕೆ. ಎಲ್ಲಿದೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರಾ ಈಗ?
Yes, my lord. IA 1 of 25. We filed a joint affidavit, my lord.
Both the sides have knowledgeably, voluntarily and amicably settled the list between them. And accordingly, they have moved an application under Order 23, Rule 3, read with Section 89 of CPC 1908, read with Article 226 of the Constitution of India and Rule 38 of the Karnataka High Court Writ Proceeding Rules 1977, reporting settlement. Full stop. We have our ಇನ್ನೊಂದು ಕಡೆ set party ಜಾರಿದ್ದಾರೆ.
Yes, my lord.
Their signatures appearing on the affidavit as well. Full stop. The joint affidavit also bears the signatures of learned advocates appearing for the parties. Full stop. Next paragraph. A perusal of the joint affidavit prima facie shows that the settlement is in the best interest of the parties and there is no fraud or the like that has influenced the decision making concerning the settlement in question. First off, we do not see any legal or factual impediment for recording the settlement and accordingly disposing of this writ petition. Onde tane?
Yes, madam.
This writ petition by setting aside the order putting.
That order was for transposition. Now we will report the settlement.
ರಿಪೋರ್ಟ್ ಮತ್ತೆ ರಿಪೋರ್ಟ್ ಮಾಡೋದೇನು ಮುಗಿಸ್ಬಿಡಿ ಇದು ಮತ್ತೆ ಅಲ್ಲಿ ಇನ್ನೊಂದು ಸಿಟ್ಟಿಂಗ್ ಆಗೋದು ಬೇಡ.
Because that arbitral tribunal, my lord, we have to file the settlement so that the.
Settlement you have filed affidavit ನೀವು.
Yes, yes.
Where is the settlement?
That's at
ಕೊಡಿ.
page 5.
Page 5.
Yes, ma'am.
ಅದೇ settlement ಮಾಡೋದು.
We have undertaken to report to the honorable.
We are reporting more set of fees to all the concerned. Page number
5, my lord, the
Memorandum of understanding it is.
memorandum of understanding.
Final
First
settlement.
Page number 5. In terms of the above, the pending arbitration proceeding,
786 of 2024,
from which
before
this
the
petition arises and this petition as well are disposed of.
Grateful.
Disposed of.
Okay.
Cost made easy. ಅಲ್ಲಿ ಆರ್ಬಿಟ್ರೇಟಿವ್ ಫೀ ಏನಾರ ಕೊಡೋದಿದೆಯೇನ?
All paid.
ಫೀ ಕೊಡೋದಿದೆಯಾ?
Paid.
You have paid the fee.
Yes, yes, yes.
Learned advocate when asked, Shri so and so, when asked, specifically submits that no fees are due to the arbitrator. Correct? ಅಥವಾ ಕೊಡ್ತಿರೋ ಹೋಗಿ?
Yes, my lord.
ಇಲ್ಲ ಗೊತ್ತಾಗಿದೆ. In fact, learned arbitrator wanted to return our side of fee because of the dispute, but we have not encashed it. We have in fact couriered back to him saying we don't want.
Learned counsel appearing for the petitioner submits, no part of the fee is repayable by the arbitrator to his client.
Lord, the fees to the mediator, my lord.
Shankar sir.
ಅವ್ರದ್ದೊಂದು mediator fee ಕೊಡ್ಬೇಕಲ್ಲ?
Yes, ma'am.
On the 3 lakhs ಕೊಟ್ಟು.
Please, ma'am.
Both the sides are directed to deposit a sum of rupees 1.5 lakh each in the registry of this court and the said amount to be handed to the learned arbitrator.
Prejudicial to the revenue. Now, on that prejudicial to the revenue. Now, on that jurisdictional point itself, I would only like to point out this, my lords. Initially, they had taken out a revised assessment, in which the transaction is this, my lords. I dispatch my goods from Bangalore to Haryana. This is on stock transfer basis to my
Any
own.
urgency involved?
Yes, my lord.
ಏನ್
Because
urgency?
ಏನ್ urgency ಅಂದ್ರೆ they will recover the amounts. The order, annexure B, if your lordship sees, is passed on 17/3/2025. And normally within 60 days, 30 days to 60 days, they recover.
Issue emergent notice. Learned AGA Mr. Aditya Vikram Bhatt is requested to. ಯಾರು ಬರ್ತಾರೆ? Aditya Vikram Bhatt is requested to accept notice for the respondents. Full stop. No precipitatory action shall be taken pursuant to impugned order till next date of hearing.
Impugned orders. Deeply applied.
I'll heard learned senior advocate Mr. Guram, first line. Okay.
Deeply applied.
Yes. Yes. Abhinav.
Yes,
Any-
Lord. Proceeding under the land grabbing quota, Lord. Lord, the order under challenge is, my Lord, the order passed on hearing before charge. My Lord, complaint is against, my Lord, a totally different person, but action is sought to be taken against me. Please turn to page number 41, my Lord.
41.
Yes, my Lord, where the complaint is given.
ನಿಮ್ಮ against ಇಲ್ವಾ?
Nam against ಇದೆ, but please turn to page number 41. I will read, my Lord, what is mentioned there. My Lord, towards the north, there is a road.
ನೀವು discharge ಕೇಳಿ.
Hearing before charge ಅಲ್ಲಿ they have made observations against me,
ಏನಂತ?
which will come in the way, my Lord, in the.
ಬರ್ಕೊಳ್ಳಿ. HBC ಆದ್ಮೇಲೆ discharge ಬರಲ್ಲ. That's what my brother is saying. I don't know much about criminal law.
Here before charge. ಬರಲ್ಲ.
ಬರಲ್ಲ. ಬರ್ಕೊಳ್ಳಿ. issue emergent notice. Interim order as prayed for. Learned AG is requested to accept notice for the respondents 1 and 3. CPS Karthikeyan, learned panel council is requested to accept notice for second respondent. Emergent notice to respondent numbers 4 and 5. Interim order as prayed for. Okay. Even before charge, court itself will do it. The application ಹಾಕುವಾಗತ್ತೇನೂ ಇಲ್ಲ. Application ಹಾಕಿದ್ರೆ ಅದು ಸೇಮ್ ಏನ್ ಡಿಫರೆನ್ಸ್ ಇದೆ 227 ಅಥವಾ 239 239. Yes.
Yes, Lord, the petitioner is serving as a PDO.
Yes.
At Surajakkanhalli Gram Panchayat, Anekal Taluk. Lord, I came to the present post, Lord, on 7/9/2023. 7/9/2023.
23.
Yes, for annexure A1, Lord, page 27.
Retention period.
Lord, that is for a period of, Lord, 2 years.
2 years.
Yes. Lord, while I was discharging my duties, during for annexure 2, page 28, to lodge a complaint against the persons who have, Lord,
done this,
who have, Lord, fraud, who have, Lord, forged my signature. Lord, no steps are taken. Ultimately, Lord, the chief executive officer passed the suspension order, annexure A6, my lord. Annexure A6. This order is dated, my lord, 6/2/2025. On page 42, the date of the suspension order is shown as 6/2/2025. Lord, I challenge the suspension order mainly on 2 grounds. One is, Lord, as per annexure A5, page 35, there is an amendment to, Lord, Karnataka.
Who is the competent authority to?
According to me, it is the commissioner. According to me, because.
Point is
No,
covered
just
by
one
your
second.
lordship
Take one
statement.
second. According to me, my lord, there is an amendment, my lord, annexure A5, page 35. The operative post is on page 38, schedule 2 says, who is the competent authority, my lord, so far as the PDOs are concerned. It is page 38, may I kindly see for a minute, my lord. Page 38.
These are the.
Yes, appointing authorities, Commissioner of Panchayat Raj. Page 38, my lord. The schedule 2, category of posts, appointing authority and cadres. Scheduled now, this amendment, my lord, came into scheduled now. This amendment, my lord, came into force, my lord, during 2024 itself.
With effect from?
With effect from 2024. That is, my lord.
ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿದೀವಿ ನಾವು. Appointing authority is one thing. Suspending authority is another. His power remains intact.
Lord, I have looked into the, my lord, order passed by your lordships. My lord, my contention is the amended, my lord, amendment has taken place during 2024. 2024.
Kindly see that page 5 of our judgment.
Yes.
Copy ಕೊಟ್ಟಿದೆ ಅವರಿಗೆ objection.
After vacation ತೊಳಿ ನಮ್ಮನ್ನ ಬೇಡ.
Suspension.
ಅಲ್ಲ ಯಾಕಂದ್ರೆ we have rejected this contention actually.
My only thing is, my lord, it requires examination for the immediate purpose. Even though the amendment specifically says that it is the commissioner who is competent to, my lord, place me under suspension. He is the
Not
appointing
suspension.
authority.
Appointing authority ಅಷ್ಟೇ
Appointing
ಹೇಳ್ತಾರೆ.
authority.
Suspension power remains intact.
Appointing authority.
Correct.
If, my lord, the CCA rules, my lord, that 10(1) says it is only the appointing authority, my lord, who can place me under suspension. Even though, my lord, this suspension order is, my lord, 2025, after the amendment came into force, my lord, whether the CEO is competent to place me under suspension is a question, my lord. My request, my lord, it requires, my lord, examination. Because admittedly, my lord, the order is passed during 2025.
Rule 10(2)(8)(2)(a).
10(8)(2)(a).
Yes.
The chief executive officer of the Jilla Panchayats have delegated the power to place under suspension a member, power to suspend or
place me under suspension
Because
contrary
rules-
to this amended rule. my
No,
lord.
Mr. Satish. Power, that rule remains intact. That is not amended. ಅದನ್ನೇ ನಾವು consider
No doubt, my lord, it is, my lord, in the statutes right from beginning. my lord, once there is an amendment, my lord, it goes without saying that, my lord, there need not be, my lord, amendment to rule 10(1)A also. Because rule, my lord, amended rule, otherwise there is no meaning for the amended rule.
No, appointment amend ಮಾಡಿದೆ.
ಅಲ್ಲ, appointing authority ಯಾರು ಅಂತ define ಮಾಡಿದ್ದಾರೆ.
Suspending authority ಯಾರು ಅಂತ ಅನ್ಕೊಂಡು ಅಲ್ಲಿ ಹೇಳಿಲ್ಲ.
It is only the appointing authority. 10(1), my lord, kindly say, my lord, your lordship is every day, my lord, examining this, my lord, rule 10(1)A. This, my lord, rule 10(1)A. My lord, the appointing authority or any authority to which
or any authority.
It is a subordinate or any other authority empowered by the government.
Government has empowered the chief executive officer.
Where is the empowerment, my lord? Where is the, my lord?
Rule.
Because
10(8)(2)A.
Yes.
10(8)(2)A.
Yes,
The chief executive officer of the Jilla Panchayats are delegated the power to place under suspension a member of the state civil service belonging to Group C and Group D of any department other than Karnataka Judicial Department working in the jurisdiction of Jilla Panchayat. Group C no Group D no ಇವರು.
ಇಲ್ಲ Group C.
ಮತ್ ಬಂದು ಹೋಯ್ತು.
Group C.
Section rule ಹೇಳುತ್ತಲ್ಲ.
My lord, if, my lord, even though, my lord, there's an amendment.
Take chance.
Even after, please.
Take chance before some other.
I'm not happy to take, my lord, judgment before your lordships also.
After the vacation.
Like, your lordship should not feel this. I'm
No, not
If
like
lordship.
that. ಅಲ್ಲ ಒಂದೊಂದ್ಸರಿ
Only thing is, it
No, no,
requires
one-
examination. I leave it alone.
Let us see. Yes. Yes.
Petition is, the lordship is not the owner of the property, he is a builder, your lordship.
Builder.
Entered into an agreement with the original owner. Lordship, there is no allegation of any deviation, my lordship, nor violation of plan. In spite of the same, my lordship, now the land grabbing court initiated the proceedings against the petitioner who is a builder, not against the original owner of the property.
You are only builder.
Builder.
But you become under the development agreement.
So that is true, my
You,
lordship.
your interest in the property is vested in you also.
Lordship, have constructed in accordance with license and sanction plan, there is no
That's all right.
deviation.
But your building agreement is dated what?
Lordship, it was in the year 2011, your lordship.
11, before the act came into.
Lordship, before the act.
Before the act came into.
2020 in a complete act.
Workali. Issue emergent notice. Learned AGA is requested to accept notice for
Respond number 2.
response number 2.
So I may
One
permit it.
Karthikeyan.
Please.
MS Subramaniam, learned panel council is requested to accept notice for first response. ಮೊದಲದನ್ನ ಬರೆದು ಆಮೇಲೆ ಗವರ್ಮೆಂಟ್ ಅಂತ ಮಾಡಬೇಕು. ನಮ್ಮ ತಹಶೀಲ್ದಾರ್ ಮಾಡಬೇಕು. Interim order as prayed for. First off, this interim protection is granted in as much as the conveyances in question precede the coming into force of 2012 Act.
Yes, my lord.
Full act ಹೆಸರು ಬರೀ.
Like.
Shravan Madhav. Yes, Shravan Madhav. Yes.
Functioning of STP may not be adequate for the number of people that are there, etc. Therefore, I applied for expansion of the STP, this thing. That expansion permission was granted. I have the validity up to 2028, though I have already installed it and approval is to be done. That was one aspect. At that stage itself, penalty was sought to be levied, I was sought to be prosecuted, which resulted in my approaching this court. Kindly see page 107. And that matter is pending. Of course, it had come up before your lordship as a learned single judge, my lord. Interim order of stay is granted. This matter is pending.
Stay is continuing.
Stay is continuing. This matter is pending. And in pursuance of the consent given by them, I have installed the expanded STP. Approval, etc. is yet to be done. First aspect. Second aspect.
Other DB judgment ಏನದು?
I'm coming to that. We are required to provide solar battery, this thing for common area. solar water heater for each of the apartment, and also DG set. Pollution control.
That order also.
No, the order also. Then
ಅಂದ್ರೆ ಶೋಕಾಸ್ ನೋಟಿಸ್ ಟೈಪ್ ಟ್ರೀಟ್ ಮಾಡಿದ್ನ ಅಂತ ಹೇಳಿ.
ಹೌದು, ಟ್ರೀಟ್ ಮಾಡಿ ಡಿಮ್ಯಾಂಡ್ ನ ಕ್ವಾಶ್ ಮಾಡಿದ್ರು. ಉಳಿದಿದ್ದನ್ನ ಶೋಕಾಸ್ ನೋಟಿಸ್ ಅಂತ ಟ್ರೀಟ್ ಮಾಡಿ ಎನ್ಕ್ವೈರಿ ಮಾಡಿ you take steps, prosecution, demand, penalty, etc., all these things. When this was in this court, a complaint is now filed before the consumer court in respect of only these aspects that your lordships would get at page 130, 130.
Issue emergent notice, interim order as prayed for till next date of hearing. ಏನಂತ ಕೇಳಿ ನೀವು ಇಂಟ್ರಿ order?
ಅಲ್ಲಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ನ ಸ್ಟೇ ಕೇಳಿದೆ, ಕನ್ಸ್ಯೂಮರ್ ಕೋರ್ಟಿನ ಪ್ರೊಸೀಡಿಂಗ್ಸ್.
ಅಲ್ಲಿ heard learned senior advocate Mr. Jaykumar S. Patil. First, ಕೆಳಗಡೆ ಬರಿಬೇಕು. In giving this interim protection, we have kept in our view the division bench judgment in
page 49
in
WP 5389 of 2020 and connected cases. 5389.
5389 of 2020 and other connected matters heard and disposed of on
assistant executive engineer grade 1. My lords, I pray, my lords, page number 78. There are 3 methods are available at serial number 11 as such.
Page number
78, my lords, the annexure starts. C&R rules, B1, annexure B1. And page number 81 is the relevant cadre. Serial number 11, my lord. Assistant executive engineer grade 1. 75% by promotion from the cadre of assistant engineer grade 1. Then rest of the things I can skip over, my lord. Straight away I can bring to my lord's notice. Next page number 2. 20%, next page, my lord. 20% by direct recruitment on the basis of the competitive examination conducted by the Karnataka Public Service Commission in accordance with the scheme specified in section schedule 2. Then, my lord, number 3 is important from my point of view. 5%
by direct recruitment from amongst in-service
candidate. My lords, we are the in-service candidates. Requirement is the 5%. We are entitled for 5%. My lord may kindly see.
In case if 3 del baratta no?
30, now the 30 posts have been declared. Ultimately, my lords, I'll be able to, it is purely a mathematical, calculation. I can point out that when 30 posts you have declared it, I'm entitled for 5. Please reserve for 5 for the in-service candidate and then answer result. That's all. That would be my endeavor.
But only the interim order is challenged, my lord. And the date given after the interim order is also passed. The interim order which is challenged is 24/2/2025. Later on, it is listed on 7/3/2025.
Correct. The arithmetical calculation. Yenide maternal. He is saying, even going by simple arithmetics of 8th or 9th level, perhaps for 5th or 6th level. So apparently, you go this to the tribunal. Yarde nimishad case is alive. Issue emergent notice. Interim order as prayed for.
Not to announce the results.
ಏನಂತ ಕೇಳಿರಿ ನೀವು?
Not to announce the results, nothing beyond.
First, this order shall not come in the way of the subject application being heard and decided by the tribunal in accordance with law. ಏನ್ರಿ ಎಷ್ಟು ಸಿಂಪಲ್ ಅಸಹ್ಯ ಬರುವಷ್ಟು arithmetical calculus. Of course, our Karnataka High Court is accused of being very bad in arithmetics. Is also true in Jayalalitha's matter. Apex Court said that way, but not in every case. Rule 3. One nimisha. You continued as your services are continued.
Well, under the Act, my lord, I became the cluster university employee, my lord, only on 36/2022, my lord. 36/2022. Lord, Act specifically Act has, my lord.
Act came into force when?
Lord, it came into force in 2019, my lord. Amendment Act came into force, my lord, in 2019. On first day of March 2019, my lord, it came into effect. Lord, under section 14 of the Amendment Act, my lord, section 40 of the Principal Act, Universities Act, my lord, came to be amended and providing, my lord, to prepare statutes also for Maharani Cluster University.
Rule 4, section 14 says what?
Section 14, my lord, provides to, my lord, prepare statutes, my lord, for Maharani's Cluster University also.
ಅಲ್ಲ ಬೇರೆ ಕ್ಲಸ್ಟರ್ ಯೂನಿವರ್ಸಿಟಿ ಆದ್ಮೇಲೆ ನೀವು ಅಲ್ಲಿಗೆ ಹೋದ್ರಿ?
ನಾನು ಅಲ್ಲಿಗೆ ಹೋದೆ. ಕ್ಲಸ್ಟರ್ ಯೂನಿವರ್ಸಿಟಿ ನಾನು ಹೋಗಿದ್ದು 30/6/2022 ಹೋಗಿದ್ದು.
ನೀವು ಹೋಗಿದ್ದು?
ಹೌದು ಸ್ವಾಮಿ. Because, my lord, I was working in Maharani college only. I was working in Maharani college only. When the act was published, my lord, I was working in Maharani college only. But only when, my lord, this government order came to be passed on 30th, my lord, I was working in Maharani college only. But only when, my lord, this government order came to be passed on 36/2022. Lord, even the statutes also, my lord, has provided, my lord, in this orange flag.
ಎಲ್ಲಿದೆ?
It I produced in the orange flag, my lord. Non-teaching, so. Lord, I was transferred, my lord, by government order dated 36/2022. That is annexure, my lord, R10, page number 338, my lord.
R10.
Please, my lord, in the second volume of the booklet, my lord.
Second volume ಕೊಡಿ.
This is a government order, my lord, college section I like merit, my lord. Page number 338, my lord.
338.
Please, my lord.
Proceedings of the government.
Please, proceedings of the government. ಕಾಲೇಜು ಶಿಕ್ಷಣ ಇಲಾಖೆಯ ಬೋಧಕ ಮತ್ತು ಬೋಧಕೇತರ ಸಿಬ್ಬಂದಿಗಳನ್ನು ನೂತನವಾಗಿ ಸ್ಥಾಪಿತವಾದ ಮಾರ್ನಿ ಕ್ಲಸ್ಟರ್ ವಿದ್ಯಾಲಯ ಸೇವೆಯಲ್ಲಿ ವಿಲೀನಗೊಳಿಸುವ ಕುರಿತು. So this is the government order passed only on 30 date, my lord, is on page number 339.
ಅಲ್ಲಿವರೆಗೆ you were employee of?
Also, I was employee of the state government. ಹಾಗಾಗಿ when, my lord, the respondents, my lord, given the placement to the similarly situated persons, my lord, I was in their only contention is that, my lord, I had become Maharani Cluster University employee as on the date of consideration.
As on that date he had
As on the date of consideration, I would say they have not said anything. I don't know anything about it. But only thing is that, my lord, they have given this document saying that, my lord, first applicant, my lord, his case has been rejected. It is not their contention that, my lord, I was not recommended at all. They say in the reply, my lord, that I had only become the employee of the Cluster University, therefore I am not eligible.
That's the only.
That's the only inference has to be. Page number, my lord, kindly see page number. Page number 285, my lord.
280?
285 of second volume. This is a reply, my lord, filed by the respondents. 285, para number 25, my lord. May I read, my lord? They speak only about me in this para. Had they not recommended my name, my lord, they would have said my name also has not been recommended, which they have stated in para 14 to the first applicant.
No, para 25 one.
Please, how this, para 25. May I read, my lord? It is submitted that the second applicant was working in Maharani Women's Arts, Commerce and Management College, Bangalore. And while he was working in the said institution, the government established Maharani Cluster University, Bangalore, comprising of Maharani Women's Arts, Commerce, so and so University for men. And by bringing the above amendment to Karnataka State Universities Act 23/2019, a copy of the Amendment Act is on Annexure R9 for kind persons. Further, it is
ಇದರಲ್ಲಿ ನಿಮ್ಮ ಹೆಸರು ಇಲ್ಲ ಅಂತ
ನನ್ನ ಹೆಸರು ಇಲ್ಲ. Subsequent because I had become the cluster employee, my lord, ಇದರಲ್ಲಿ ಇಲ್ಲ. ಈ ಲಿಸ್ಟ್ ನಿ ಆಪರೇಟ್ ಮಾಡಿ they have given the benefit. But my lord, as the government has already passed an order, my lord, giving retrospective benefit to the employees of those who have been placed along with me, the date doesn't become material, my lord.
What is the benefit you should be given now?
Career advancement scheme under CAS, my lord, as professor, my lord, from associate professor to the post of professor.
It's not dependent upon vacancy at all.
It's not dependent upon vacancy. It's only requirement, my lord, UGC specifically says under page number 305 that, my lord, I should be in active service as on the date of consideration, my lord.
That was before 36.
Yes, that was before 36. That is only my submission.
Yes. Why he was not considered?
My lord, the consideration, his consideration which was done in February 2022, my lord, that was based on the 2010 regulations. That was because in 2018 when the regulations were introduced, as per regulation 6(3), my lord, the UGC said they can opt either for the 2010 regulations which were more
ಏನು regulation
6.3, my lord.
6.3.
Last. The candidate who does not
The
succeed. in the first
criteria.
Please, criteria for promotions under the career advancement scheme. May I read, my lord? I continue reading. The criteria for promotion under the career advancement scheme laid down under these regulations shall be effective from the date of notification of these regulations. However, to avoid hardship to those faculty members who have already qualified or are likely to qualify shortly under the existing regulations, a choice may be given to them for being considered for promotions under the existing regulations. This option can be exercised only within 3 years from the date of notification of these regulations. So this period would end in 2021, my lord.
2021.
The 3 years.
No, option is for what? To the earlier notification.
Whether you want to be, because the API scores have to be calculated based on publications.
Option is for what? For 2010 regulations.
Whether you want to be regulated by the 2010 regulations or the 2008
No,
regulations.
he will not exercise option. Then the 2018 will apply.
Yes.
Yes, my lord.
Then where is the question of option?
My lord, what had happened was we considered them based on the 2010 regulations.
Where is the option?
That was rejected by the.
No, where did he give option for 2010 regulation?
My lord, whether it was under 10 or 8, my lord, why nothing happened till 21, that the explanation may see the application, my lord.
Show that. Application ಬರಲ್ಲ.
KT application.
Option ಅನ್ನು ಕೊಡಬೇಕು. ಅಲ್ಲ, application ನಲ್ಲಿ 10 ಹೇಳಿ ಅವರು. In terms of 6.3, they should give an option saying that I don't want to be governed by 2018. I want to be governed by 2010. Optional format ಏನ್ರ ಇದೇನು?
In fact, my lord, his proposal was submitted in both the 10 and 18 regulations also.
where is your application for CAS benefit?
For that application I have submitted there. It's
Not produced.
online. It is.
Online applications. Your ground as to why he was not considered is, what is your ground? As to why he was not considered is, what is your ground?
Only
maybe
ಇಲ್ಲ ಕೋವಿಡ್ ಟೈಮ್ ಇತ್ತು ಸ್ವಾಮಿ ಆ ಟೈಮಲ್ಲಿ ಬಿಕಾಸ್ ಅಂಡ್ ಆಲ್ಸೋ ದೇರ್ ವಾಸ್ ಐ ಆಲ್ಸೋ ಪಾಯಿಂಟ್ ಔಟ್ ದೇರ್ ವಾಸ್ ಒನ್ ಮೋರ್ ಡಿಫಿಕಲ್ಟಿ.
ಬೇರೆಯವರಿಗೆ ಕೊಟ್ಟಿರಲ್ಲ.
ಇಲ್ಲ ಯಾರಿಗೂ ಕೊಟ್ಟಿಲ್ಲ. ಯಾರಿಗೂ ಕೊಟ್ಟಿಲ್ಲ.
ಎಲ್ರಿಗೂ ಕೊಡಬೇಕು. ಅದು ಇರೋದೇ CAS. It does not depend upon vacancy at all.
My lord, vacancy is relevant. My lord, your lordships may kindly see the same paragraph, the same regulation.
Vacancy based CAS.
ಅಲ್ಲ 10% of associate professors will be made professors.
Vacancy alladu percentage.
And my lord,
vacancy based alladu. There need not be vacancy for CAS promotion. CAS promotion is personal status.
ಅಲ್ಲ how many persons can be appointed as professors ಅನ್ನೋದು will depend upon the strength of the associate professors.
Correct. ಎಷ್ಟು ಜನ ಆಯ್ತು?
10%. My lord, there were 1,252 associate professors.
All right. 120 ಜನರನ್ನ 122 ಜನರನ್ನ ಮಾಡಬೇಕಾಗ್ತದೆ.
126 ಸ್ವಾಮಿ 10% ಅಂದ್ರೆ
ಜನರು ಮಾಡಬೇಕು. ಅದರಲ್ಲಿ ಬರಲ್ವಾ ಇವರು?
With the further condition that there shall be only one professor for each department.
Correct. ಅದರಲ್ಲಿ ಬಂದ ಕನ್ಸಿಡರೇಷನ್ ಆಗಿಲ್ಲಲ್ಲ.
ಅಲ್ಲ ಅದು ಮಾಡೋಷ್ಟೊತ್ತಿಗೆ that is the reason for all these delays. That is what that is why I am explaining the delay.
Some politics.
Para 6 ನಲ್ಲಿ ಇನ್ನೊಂದು ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ he should be in active service ಅಂತ ಹೇಳ್ತಾರೆ.
ಹೌದು, he was in active service till 36/2022.
But when the
even after 36/2022 he is in active service.
The impugned order,
another university.
ಅಲ್ಲ the impugned order which he challenges, that is dated November 2022, my lord. But by that time he had become a employee of the cluster university.
That's all right.
In
but
June 2020,
as on the date the impugned order was made, he was still the employee.
No, my lord. The impugned order
on which date?
My lord, in 2021, my lord.
Yes.
2021.
Yes.
ಎಲ್ಲಿದೆ? ಯಾವ ಡೇಟ್ ನಿಂದ ಬರ್ತದೆ?
Lord, it is annexure R3, my lord, 2020. It is on 18 July 2018 itself which came into publish. 18 July 2018, my lord. Page number 303.
My lord, that is the UGC regulation.
UGC regulation.
Adoption was in 2021, my lord.
Yeah, where is the option for you to adopt?
My lord, it is based on the honorable apex court decision. In fact, your lordship asked this very question, my lord.
Yes.
Your lordships may notice the relevant extract is at page 328, my lord. 328, my lord. Lord, the bottom of the page. Further, my lord, I'll read from, my lord, below the words chief secretary, which are in capitals. The words further, I'll start from the word further, my lord. Further in the judgment dated 17/7/2013.
P.U. Joshi.
Rendered, not P.U. Joshi, my lord. This is
chief secretary. Chinnaga Lakshmamma. Page number 328. Page number
328, my lord.
Correct.
328.
Chief Secretary and others on the above reasoning. Further in the judgment dated to under by the Honorable Supreme Court. Chief Secretary and others on the above reasoning. Further in the judgment dated to under by the Honorable Supreme Court in so and so and so. While dealing which the order of the KAT. Yes, this is the order of the KAT.
Please.
But you adopted
the apex court judgment is Jagdish.
You adopted 2018 regulations when?
My lord, in March 2021. My lord.
So he was already employee. He was employee of the same government employee only.
He was, my lord. My lord, but the consideration took time, my lord.
How much? How much?
My lord,
how can you say deny this relief in 2021? On which date you adopted? Date of adoption, Hedi?
March 2021.
My lord, 2nd March 2021 is what I'm told, my lord.
2/3/2021. 21. 9/2/2022 was the
Consideration.
Please, ma'am.
You have considered. Therefore, you ought to have considered his case. Though you rejected those candidates. Question is, you could not have rejected his candidate.
My lord,
What ground you can reject that CA's promotion?
my lord, the finance department did not concur with the 2010 guidelines, my lord.
2018.
2000. Therefore, consideration was made once again 2022.
Correct.
That list has been challenged.
Challenged in the sense, his name should have been considered. That consideration has not happened. If you have considered others, were they juniors to you?
Yes, Lord.
They were juniors.
They were juniors.
May I just pass this on, my lord? This is the order of the government. May I just pass this on, my lord? This is the order of the government pursuant to which the list in which he found a place was not implemented, my lord. In fact, that list, when it was sent for to the
But that was
government.
not, what was your objection? Your objection before the KAT?
Yes, ma'am. That's
Can
page
you
number
go on
20.
changing?
But the objection before the KAT was that he already had left because he cannot be included in the November 2022 list
No,
because
that
he was
ought to
already.
that ought to have happened, consideration ought to have happened when he was there.
That, my lord, his challenge is only to the 11.
Challenge is non-consideration of his case.
Non-consideration of his
Of
case in
November-
the list
November
prepared
20
in November 22,
November 2022.
when he was not an
When
employee of
others
the,
were considered.
when
You
he was
might have
not.
rejected. You might have rejected others also. But where is the consideration of his case?
My lord, in November 2022.
He was no
since
longer.
he was no longer there.
Correct. Then does it mean that he should not get anywhere?
My lord, he
Oh.
should, my lord, he
Yes,
should be
yes.
considered by the cluster university, my lord, not by the, is no longer a civil servant as on that date. And rule 6.3 also states that he should be in active service on the date of consideration.
As on that?
As on the date of consideration, my lord,
Correct. He was in the active service,
He
though
was-
in the cluster university.
in the cluster university.
He was in the active service only.
Of state government employment.
He was in the cluster university, my lord.
We are allowing this petition with caution. You want to say anything?
Since he had left the civil service in June 2022.
Active service of university,
College or university?
college or university?
Please.
Both are
College.
included.
College.
No, university is also included.
Yes.
My lord, university is autonomous body, my lord. They are not civil servants. Employees of the university are governed by the regulations of the university itself.
Then if we accept your contention, he will never get the promotion at all.
My lord,
Though he fulfills all the conditions.
he will never get.
We are only asking, why?
My lord, I'm only stating this as an officer of the court, my lord. There has been a delay, but because there have been lot of confusions over how the CAs had to be implemented regarding the calculation of the API, and nobody was considered until 2021. And the consideration which happened in February 2022 was not completed because the government rejected the recommendation sent by the department, my lord. May I just take your lordships through this order which I just passed, my lord. This is the reason why the list in which he was.
Other matters, what we did in that Satnarayana Gowda.
In that case, my lord, my lords can hold that, my lord, the interview itself is not required.
There we said interview is not required because librarians interview iತ್ತು.
ಹೌದು, librarians-
These professors, no interview was there.
ಹೌದು.
Straight away the recommendation ಮೇಲೆ ಮಾಡ್ಬಿಡೋದಿತ್ತು. ಆ ರೀತಿ ಹೋಲ್ಡ್ ಮಾಡಿದವು. Any challenge led to that one?
It has not been challenged. It has not been challenged. But once they prepare, my lord, and the submission is not made.
Where is that recommendation?
My lord, 2010.
The one which you are now.
The one is the new one, my lord. Latest one is the impugned one. The one which is impugned at annexure A1.
Anyway, post it day after. ಒಂದನೇ ತಾರೀಕು ಇವತ್ತದು. We'll just go because other matters are here. ಕರೀರಿ ಇವ್ರನ್ನ ಎಲ್ಲ ಕೇಳಿ. Yes. ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ ಈಗ?
Lords, before my lords today, we have 62 persons, lords, that which are already in the list. Andre ivattu list ಆಗಿರೋ cases in the 1030 list. There are 62 petitioners.
ಅಲ್ಲಿ ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ?
There we have 26.
62, 26.
88 ಆಗುತ್ತೆ.
88 people.
And out of the 20
ಮಾಡ್ಬಿಡಿ. ಯಾಕಂದ್ರೆ ನಾವು ಇಲ್ಲಿ ಅಲೋ ಮಾಡಿದ್ರೆ
Even
others also may be.
my lords have already passed an order. In the
To
previous
that
order,
effect.
to that effect, to place even the result of the other eligible candidates also before the court, even the as well as the petitioners before the court. Please, my lords. My lords, only thing is one cutoff, and my lords, I'll just point out what we did. My lords, in respect of the candidates who are eligible for main exam, they had to apply online. But in view of the fact, my lords, that the urgency was there, we have, my lords, uploaded the application form in the website. They can, whoever is eligible now to write in terms of the court order, they are supposed to download that application form, fill it up manually, my lords, and come and give it to us. And because they have to give preferences and they have to, with regard to the services and other things, and we will arrange for that. Only thing, my lords, if a quotas is given to the number of people, my lords, that we have to accommodate as of now, then we will accommodate, my lords. We will accommodate.
But again, we are asking you.
Please, my lords.
Suppose in the event they succeed, even one petition succeeds.
Please, my lords.
Everything will go.
No, my lords, that if they are allowed to write the main examination, then, my lords, it will not play out in that manner. It will play out in a different manner, totally different manner. It is like this. The eligible, the purpose of conducting a preliminary examination is, my lords, for the purpose of determining the eligibility to write the main examination. It's a filtering mechanism because more than 1 lakh people have applied, and, my lords, more than 1 lakh people have taken the examination, and now, my lords, only 5,000 odd people, my lords, are eligible for the main examination. Now, at the end of the day, if suppose we allow, my lords, some people to write who are not qualified for the preliminary examination by virtue of an interim order to write, if they become eligible to be called for interview, then only those cases have to be considered. Now, tomorrow, if, my lords, if some order is passed now, including
Be duplicated in the tribunal also.
ಇಲ್ಲ my request is ಅಲ್ಲಿ duplicate ಆದ್ರೆ ಅಲ್ಲಿ ಆ ಡುಪ್ಲಿಕೇಶನ್ ಇನ್ನೊಂದು ಸೆಟ್ ಆಫ್ ಪೆಟಿಷನ್ಸ್ ಬೀಳ್ತವೆ ಅಂತ. So I wanted to be therefore, my lords, I have the numbers, and those people are already before my lords, some of them, I'm told.
The exam center will be in Bangalore or what?
My lords, we have only two Bangalore and Dharwad are the two exam centers, consisting of 8 in Dharwad ಅಲ್ಲಿ 8 centers, sub centers ಇದೆ, Bangalore ಅಲ್ಲಿ 90 ಇದೆ. So we will be, and we have told them that you give the manual application and pay the fees. The hall tickets will be given at the centers, but we will notify your hall tickets in the website in advance. So if it is done today, for them also, my lords, 3 days to go find out, my lords, where their exam is to be scheduled, and it is
ಅವ್ರಿಗೆ ಎಲ್ಲ ಫೋನ್ ಮಾಡಿ ತಿಳಿಸ್ಬಿಡಿ.
ಮಾಡ್ತೀವಿ.
ಇಂಡಿವಿಜುವಲ್ ಟೆಲಿಫೋನ್ ಮಾಡಿ.
We will do that. We will.
ಎಲ್ಲಿದೆ ಅವರಿಗೆ ಮತ್ತೆ ಅವ್ರು ಹುಡುಕೋಣದ್ರಲ್ಲಿ ಟೈಮ್
No, that's what, my lords. Tomorrow there should not be a complaint that despite
ಪ್ಲಸ್ ವಾಟ್ಸ್ಆಪ್ ಮಿಸ್ ಅವ್ರ ನಂಬರ್ ಎಲ್ಲ ಇರುತ್ತಲ್ಲ.
They will give the numbers.
Numbers, WhatsApp.
Tomorrow there should not be a complaint despite an interim order. I were not allowed to write examination. I don't want such a situation. If there is a cutoff today, I can ensure that whoever my lords allows, my lords, we will allow them.
ಅಲ್ಲಿ ಬೇರೆ ಇನ್ನೆಷ್ಟಿದೆ ಕೆಳಗಡೆ ಒಂದು ಫೋನ್ ಮಾಡಿ ಕೇಳ್ತೀನಿ. ಆಲ್ರೆಡಿ ಆಗ್ತಾ ಇದೆಯಾ?
Petitioners ಎಷ್ಟಿದ್ದಾರೆ? Total petitions. ಈ ಕಡೆ ಬನ್ನಿ.
ಎಕ್ಸಾಮ್ ತಗೊಳ್ಳಿ ಇವರು, ನೋಡೋಣ ಮುಂದೆ ಏನೇನ್ ಆಗ್ತದೆ ಅನ್ಕೊಂಡು.
ಅಲ್ಲ, ಈ ಪ್ರಿಲಿಮಿನರಿ ಎಕ್ಸಾಮ್ ನಲ್ಲಿ
AGA is on request accepts notice for state. ಬೇರೆ ಯಾರು ಇದ್ದಾರೆ?
State and KPSC.
Fine. So in learned senior advocates and advocates appearing for the petitioners submit that in almost identical matters, this court has granted some interim relief by directing the KPSC to permit the petitioners to take up written examination.
Main written examination.
Imminent main written examination. And that these petitioners being similarly circumstanced need to be granted same relief. subject to same conditions. First up, there is force in this submission. First up. Therefore, next paragraph. The KPSC is directed to permit the petitioners to take up a main written examination scheduled to be commenced from, held on or commenced from? Commenced from
On
3rd of
On 3/5/20.
May 2025. First up. As has been directed in, as has been directed yes. ಅಲ್ಲಿ equity shall not be pleaded ಎಲ್ಲ ಇದೆಯಾ?
Result of the examination of the petitioners and others will not be published. Equity on the admin.
ಇದೆ.
First order ಅಲ್ಲಿ ಇದೆ.
In the first order, it's always.
In the earlier, your lordship
So my-
refer to both orders. Because in the first order, equities ಇದೆ.
9708 ಅಲ್ಲಿ it is.
No equity shall be pleaded. It is again made clear that petitioner shall not plead equity of any kind whatsoever.
Both parties.
Both parties shall not plead equity.
Lots, one submission. Today's. Lots, this order in serial number 12, 13, 14, 15, 17. 12, 13, 14, 15, 17.
ಇದಾನೆ ಮಾರ್ಕ್ ಮಾಡ್ಕೊಳ್ಳಿ. Serial number
12, 13, 14, 15, 17, 26, 33, 34, 35.
9 also.
18 ಒಂದಿದೆನಾ? 9.
9 also.
No, 9 is the earlier order. 9 ಅಲ್ಲಿ 9 is the earlier order that I passed on. Let them not include 9. 9 ಬೇಡ.
9 ಬಿಟ್ಕೊಂಡು.
9 ಬಿಟ್ಕೊಂಡು.
18 ಇದೆ. Serial number 18 ಆಗ್ಬೇಕು. Serial number
18 ಆಯ್ತಲ್ಲ. 9.2 including application. ಸೇಮ್ ಆರ್ಡರ್ ಉಳಿದಿದ್ದಕ್ಕೆಲ್ಲ ಬರ್ತದಲ್ಲ ಅದಕ್ಕೂ ಸೇಮ್ ಆರ್ಡರ್. ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ದಾರೆ ಅದೆಲ್ಲ ಆರ್ಡರ್ ಇಲ್ಲ ಸೇಮ್ ಆರ್ಡರ್ ಮಾಡಿಲ್ಲ ಅದು ಇದೇನು ಫೈಲ್ ಆಗಿದೆಯಾ? Is it filed? It has not come before the court? ತರಿಸ್ಬಿಡಿ ಅದನ್ನೊಂದು ತರಿಸ್ಬಿಡಿ. How many applications? ಏನಂತೆ?
350 ಅಂತ.
ಏನಂತೆ?
350 ಅಂತ.
ನೋಡೋಣ ಟ್ರೈಬ್ಯುನಲ್ ನಲ್ಲಿ ಹೋಗಿ ಏನಾಗುತ್ತೆ ಅಂತ ಅನ್ಕೊಂಡು ನೋಡ್ಕೊಳ್ಳಿ ಆರ್ಡರ್ ಇಟ್ಕೊಂಡು ಪ್ಲೀಸ್. ಓಕೆ.
Not only if an observation with regard to that was my our worry was that now it would open up something. So if my lords make an observation, the petitions, 5 petitions listed before the tribunal.
ಇದರಲ್ಲಿ ಏನಿದೆ ಇದರಲ್ಲಿ ಇರೋದು ಮಾತ್ರ ನಾವು ಆರ್ಡರ್ ಮಾಡಿದ್ದೇವೆ, ಬೇರೆ ಯಾವುದರಲ್ಲಿ ಏನು ಆರ್ಡರ್ ಮಾಡಲ್ಲ.
Please,
we are not going to order unless they come before us.
Please,
ಮುಂದೆ ಬಂದ್ರೆ so many things will happen. ಅವಾಗ ನೋಡೋಣ.
Grateful.
ಒಂದ್ಸರಿ ಆರ್ಡರ್ ಬಂದು ನೋಡ್ಬೇಕು.
ಆಯ್ತು.
I am also one of the petitioner, my lord. I am also one among the petitioners. The order is applicable to me also, my lord.
ಎಲ್ಲಿ ಪಿಟಿಷನ್ ಯಾವುದು?
Writ petition number 14570.
Serial number.
Is it listed today?
Fresh file.
Is it listed?
I have filed, sir.
ಮೆಮೊ ಕೊಟ್ಟಿರಾ?
Memo ಕೊಟ್ಟಿದ್ದೀವಿ sir.
ಬರುತ್ತೆ. ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೆಲ್ಲ ನೋಡ್ಕೋಬೇಕು ಒಂದ್ಸರಿ ಅವ್ರ ಜೊತೆ ನೋಡ್ಕೊಂಡು ಮಾಡ್ಬೇಕು. ಮತ್ತೆ ಅಲ್ಲಿ ನೋಡ್ಕೊಳ್ಳಿ ಏನ್ ಸ್ಟ್ಯಾಂಡ್ ತೋತೀರಿ ನೀವು. ಈಗ ಒಬ್ರಿಗೆ ಅಲ್ಲಿ ನೋಡ್ಕೊಳ್ಳಿ ಏನ್ ಸ್ಟ್ಯಾಂಡ್ ತೋತೀರಿ ನೀವು. ಈಗ ಒಬ್ರಿಗೆ ಕೊಟ್ಟು ಒಬ್ರಿಗೆ ಕೊಡದಂಗೆ ಇರ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಸ್ವಲ್ಪ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ.
ಇವತ್ತು today 5 petitions are listed. I'm going to make a submission and we'll verify.
Lordship, please clarify. Lordship, small submission, my lord. Clarification.
My lordship. Grateful, my lords.
How many allowed?
No idea.
ನಮ್ ಬಂದಿದೆ.
ಸರ್ ಎಲ್ಲ ಕಾಮನ್ ಆರ್ಡರ್ ಅಲ್ವಾ? ಹೌದಾ? ಇಲ್ಲ ಸೆಲ್ಸ್ ಇದ್ದ ನಮ್ದಲ್ಲ ಸರ್.
వీళ్ళకి చెప్పాలి, వీళ్ళకి చెప్పాలి సార్. Madam, Raghavendra sir. Raghavendra sir. Some FR number 14 supplies himself.
ಮಧ್ಯಾಹ್ನ ಇದೆ ತಾನೆ? ರಾಘವೇಂದ್ರ ಸರ್ ಮಧ್ಯಾಹ್ನ ಇದೆ.
ಏನಿಲ್ಲ ಸರ್.
ಮಧ್ಯಾಹ್ನ ಕಂಟಿನ್ಯೂ ಅಲ್ಲ ಸರ್? ಬೇರೆ ಬೆಂಚ್ ಆದ್ರೂ ಇದೆಯಾ ಸರ್? ಹೌದಾ?
ಏನೋ ಕಾಂಪ್ರಮೈಸ್ ಆಯ್ತಾ?
My lords, we have filed a memo to assist this honorable court with respect to the conditions. The child is here, father is also here. Yes. There's a lot of questions. The child is here, father is also here. Yes. There's a lot of crowd outside.
Yes, allow the child with the mother.
Yes, please.
Where is the child?
She's outside. We have filed the conditions precedent. It's there in the file. Bench.
Able with that?
Bench or
ಏನೇನೋ ಹಾಕಿದ್ದಾರೆ 15 ಲಕ್ಷ ಬಾಂಡ್ ಕೊಡಬೇಕಂತೆ, ಆಮೇಲೆ ಅದು ಮುಸ್ಲಿಂ ಡಾಮಿನೇಟೆಡ್ ಅಂತೆ, ಬೆಂಗಳೂರಿನ ಕರ್ಕೊಂಡು ಹೋಗ್ಬಾರ್ದಂತೆ.
Ask your client. Banama, come this side. Madam, please come this.
It's memo kodi.
What memo ಏನಿದೆ?
Bench or memo kodi. Now.
Father, ನೀವು ಇಬ್ರು ಹಿಂದೆ. Lawyers, please go back.
Yes.
Yes, ask the parties to come here. And in camera ಮಾಡಿ. In camera ಮಾಡಿ proceeding. Set all others to be away. ಅವ್ರೆ ಲಾಯರ್ಸ್ ಅವ್ರು ಸಪ್ರೇಟ್ ಕಳಿಸ್ಬೇಕು ಅವ್ರು ಹೋದ್ಮೇಲೆ ಅದಕ್ಕೆ. Make use of my calls.
Yes, sir. Thank you.
Now lawyers may go out. Close ಮಾಡಿ ಇದನ್ನ. Where is the child? Child is here?
Yes.
Very good.
My lord, my apologies, my lord. My apologies. Perhaps video conferencing will have to be closed, my lord, if it is in camera. I'm sorry.
You're right. You're right.
I'm sorry.
Thank you. Thank you.
In camera. I'm sorry.
You're right. You're right.
I'm sorry.
Thank you. Thank you.
Grateful.